very obvious attempt by the defense to again get material admitted through those conjugal visits and telephone calls that has not been admitted in court. Please don't do this, Your Honor. I beg you, take the waiver and let the defendant admit that he will not testify and waive his right, but nothing further should be said on the record and in open court.
She knew what was coming, and Judge Ito did not stop it. Last Friday, Marcia Clark knew that O.J. Simpson and his lawyers would in fact turn the formality of the defendant's waiver of his right to testify into an opportunity for Simpson to give a self-serving speech. The jury wasn't in the courtroom, so it may mean nothing in the long run, and defendants do address the court directly at appropriate times. Judge Ito invited Simpson's waiver and the reasons for it. Still, one cannot help but wonder if this were not O.J. Simpson, the rich celebrity, but some kid from the wrong side of the tracks, flanked not by a half-dozen high-priced lawyers, but by a hard-pressed public defender, would the court have been as indulgent as this?
Good morning, Your Honor. As much as I would like to address some of the misrepresentations made about myself and Nicole concerning our life together, I'm mindful of the mood and the stamina of this jury. I have confidence, a lot more it seems than Ms. Clark has, of their integrity, and that they will find, as the record stands now, that I did not, could not, and would not have committed this crime. I have 4 kids, 2 kids I haven't seen in a year. They ask me every week, Dad, how much longer?
All right.
This trial over. Thank you.
All right. Mr. Simpson, you do understand your right to testify as a witness?
Yes, I do.
All right. And you choose to rest your case at this? All right. Thank you very much, sir.
It was a great moment for O.J. Simpson. Afterward, Johnny Cochran explained why his client was so determined to speak out, but not under oath.
At the moment he stood up, he was very emotional. You think he prepared the fact that when he started talking about his children he became tearful, or that his daughter broke down and started crying? That was spontaneous, because it's very emotional. When you've been in custody for this long for a crime you maintain you didn't commit, and you never got a chance to talk, and you got a chance to say something today. You've seen all these things happen to you. It's pretty hard.
O.J. Simpson's statement that he wasn't taking the witness stand to testify under oath and face cross-examination because he was concerned about the stamina of the jury was, frankly, disingenuous. Jurors are always riveted by the testimony of any defendant. It is the most dramatic evidence in a trial when it comes. The fact that it did not come in this case, and that the defendant nevertheless had the chance to proclaim his innocence in court, stunned and dismayed Fred Goldman, Ron Goldman's father.
If he had a statement to make, he should have gotten on the damn stand and said something, and not been a coward and been unable to have the prosecution question him. He had a right to say one thing and one thing only, and that was he didn't want to testify. I think the judge expected him only to say that, and he shot his mouth off again. He hasn't seen his kids in a year. He's seen at least 2. I will never see my son again. How dare he throw that up? For the world to hear and feel sorry for him. He's where he is because he committed murder.
Well, as this case heads to the jury now, the choice in the possible outcomes has been expanded in the instructions on the law Judge Ito gave last Friday. O.J. Simpson was originally indicted on 2 counts of first-degree murder. Under the law, that means the state must prove that Simpson killed the victims in a deliberate and premeditated fashion with malice aforethought, that he thought about killing, and knowing how evil it is, went ahead and killed anyway. But Judge Ito decided to give the jurors another choice, second-degree murder. Here's how this lesser-included offense, as it's called, was defined for the jury in Judge Ito's instructions.
Murder of the second degree is the unlawful killing of a human being with malice aforethought, where there is manifested an intention unlawfully to kill a human being, but the evidence is insufficient to establish deliberation and premeditation. Murder is classified into 2 degrees. and if you should find the defendant guilty of murder, you must determine and state in your verdict whether you find the murder to be of the first or second degree.
Returning to Ricky Kleeman in Los Angeles. Ricky, how are the lawyers going to handle this choice between first and second degree murder in summations?
Well, Terry, I think from the defense perspective, they have to beg the jury not to compromise. And that has to be their tact. And they have to go for exactly what they believe, which is that a murder to conviction is simply a compromise verdict that is not based on the evidence. The prosecution, on the other hand, has to decide what do they want and what can they get. And Fred Graham, we have to think about those perspectives, isn't that correct?
Oh, but I think it's easy to predict what the prosecution certainly would be willing to take. It would be a huge victory for this prosecution to get a murder conviction, even second-degree murder, and even on both counts, even though it's sort of runs counter to the evidence in the case of Nicole Brown Simpson. It would mean they would not have to try the case again. It would mean that the irritation of this entire case with its racial implications would be lifted from this community. It would certainly be a political plus for Gil Garcetti, the district attorney who's in some trouble now on this. So I think you're going to see Marcia Clark hold out that prospect like a plum, like a tidbit, that if this jury doesn't want to go all the way, there's a way to compromise.
It's interesting, you know, Terry, because they do say it's dangerous to argue in the alternative. That's what the legal scholars say. But here, because there's two victims, with Ronald Goldman, as Fred points out, that is a second-degree type of case. And so the prosecutor's in the catbird seat here. And before I throw back to you, it dawned on me that what I said to you before concerning Mark Fuhrman and Philip Van Adder, it's from the defense perspective, of course, that it is shown that Philip Van Adder lied. But really, it's merely an allegation. And the jury, of course, has the right to believe Philip Van Adder. And so they may think that neither Mark Fuhrman or Philip Van Adder are the police officers that ought to be disbelieved.
All right, and Mr. Neufeld, you have the court's permission to wear your prescription dark glasses until till LensCrafters manages to fix your glasses for you. All right, counsel, we're here to start the final arguments for both parties. We have a number of demonstrative pieces that are going to be used by the parties. And I understand there's some objections to some of these. Mr. Neufeld. Good morning, sir.
Good morning. Your Honor, I'm also, first of all, I'm not most qualified to argue some of the boards because, as you may recall, I wasn't even here for the early portion of the trial when some of those matters came to the forefront. What I would suggest we do, since we were also told by the prosecution that they have a whole series of slides that were specially prepared for summation that are not in evidence already, and we have to review those as well before the summation begins. What I would ask is for the court's indulgence to give Mr. Shapiro and Mr. Cochran just 5 minutes to look at the that timeline board and the so-called abuse board, which they could do very, very quickly, and at the same time we could look at the slides.
Well, that's why we started at 8 o'clock this morning, counsel.
I know, and we were here on that, Your Honor. There were some technical glitches, but one of the things we expected to see at 8 o'clock this morning also was their slideshow. We've yet to have that pre-screened for us. So I'm simply asking that we have that done, and while we're doing that...
We're going to take up the boards first, counsel.
All right.
All right, first one, evidence from the Bronco.
Well, the problem we have with the boards, which are referred to as evidence from the Bronco, evidence at Rockingham, and evidence at Bundy, allegedly connecting Mr. Simpson to those three scenes, is that the court made a very explicit ruling early on in this case that the people cannot use the term match to refer to draw a connection or nexus between hair and fiber evidence and individuals. That you in fact, had to instruct Ms. Clark repeatedly when she violated that rule to refrain from using the word match and stick to consistent
So the bottom line of your objection is that you object to the wording on the board regarding the hair and the fiber.
That's correct. Not regarding the blood, because the court drew the distinction there, but regarding the hair and fiber.
Right.
That although they're allowed to argue, they're not allowed to misstate the facts. And you set very strong parameters as to what the facts were with regard to hair and fiber.
All right, and that pertains to the evidence from Bundy, the evidence at Rockingham, and evidence from the Bronco boards, all
That's
three
right.
boards.
There was another board, which was a timeline board, and just from my initial review, and again, I would need the help of Mr. Cochran and Mr. Shapiro on this, is that there was a suggestion that Cato heard 3 knocks between 10:51 and 10:52, whereas his testimony, both on direct and cross, is 10:40 to 10:45. And there is no testimony of 10:51 to 10:52 in the record, and they have no business asserting facts on a board which don't exist in the record. So at least as to that statement of fact in the board, we would object to that and ask that it be changed. I think also you should bear in mind, Your Honor, that I believe that the prosecution has little cards and has the technical ability to make substitutions and changes depending on your rulings this morning, because they indicated that as to another time they were going to make a change and put a card on it. But again, I would like my co-counsel to just have just a 2-minute opportunity to quickly look at that board as well, because there were a lot of different times on it, and I will be the first to admit that I don't have that kind of expert familiarity with every time suggested on there, and we would just like to be able to check it.
All right, any response to the objections regarding the boards? Ms. Clark, good morning.
Yes, Your Honor. I mean, if it even needs a response, I plan to argue, as the court is aware, that Mr. Diedrich can testify to what he saw through a microscope, and that can only be deemed consistent. But when we consider all of the evidence in the case, we know that it is his hair. And this is argument. That's the reasonable inference to be drawn. At this point, I should not be confined to saying it's only consistent, because I'm not just talking about Mr. Diedrich's opinion or conclusion based solely on the microscopic comparison. I'll make that very clear to the jury. There's not going to be any doubt in anybody's mind, and I'm not going to be saying Mr. Diedrich said it was a match. I'm not going to say that either. Mr. Diedrich said it was consistent. That's all he could say. That's all he knew. But when we look at all of the evidence, we know it's his hair. That's entirely permissible, in fact, mandatory argument in a case like this. So I don't think the court needs to hear that much more from me on that. With respect to the timeline, this is the problem with having, lawyers argue that haven't been here. On the timeline thing, Cato said that he heard the thumps, and 2 to 3 minutes later he walked out of his room. Alan Park said that he was on the phone with his boss and hung up within 30 seconds of that, of seeing Cato and the defendant out in the yard. Cato on the side yard, the defendant in the driveway. We have his cell phone records that indicate that that phone call was completed at 10:55 something. It's on the board, Your Honor, in any case. So I time it by that. We have a very, very accurate way of determining when Cato went out to the side yard and when he heard the thumps based on that. Is there anything else?
Those are the 2 objections to the boards. Any response, Mr. Neufeld?
Judge, I believe that the prosecutor's argument is simply that that's when Parks saw the 2 of them, but the phone records and his testimony, both on direct and cross, is that it could have been 10:40, it could have been as late as 10:42. That's the window. They just enlarged it by 10 minutes, and there's absolutely no testimony to support that. It's the phone records even aren't consistent with that. We can pull out in 10 seconds if you want the portions of the transcript so it's crystal clear, but that number 1052 just comes out of thin air and is not supported by the facts. And I think if you just give us a minute, we'll pull it for you.
No, I recollect that there is some imprecision in the times, and the only times that we have are dated, are timestamps by the phone records. I agree with you there. However, I think that the prosecution has a rational basis to make that argument, and they make that argument if it's illogical or if it doesn't make sense to the jury. They make that argument at their peril. But since they can extrapolate, so to speak, from the testimony, I think they're entitled to make that argument. All right, the other objections will be overruled with the following modification. Ms. Clark, I'm concerned that the hair and fiber, to say that it's the defendant's hair or fiber from the Bronco when we know that the testimony is that it's consistent with, I think a labeling should be that it is consistent with. Sure.
I would understand the court's concern if it was an issue of misrepresenting to the jury what the scientific testimony was. I'm sure the court can appreciate that when everything is put together. And that's the argument. These boards are a summation. These boards are not just based on Mr. Diedrich's testimony, and I will not let the jury be misled in that regard for 1 second. The purpose of these boards is to put it all together to say when you consider everything, you know this is his hair. That's the Bronco fiber. I'm going to make it clear. I'm not going to leave any doubt in anyone's mind what Mr. Diedrich said. He could only say this. But on this board, I'm asking you to consider all of the evidence, and there's a wealth of it. And when you put it all together, you know it's his hair. And that's the purpose of closing argument, is to put it all together. So I understand the court's concern, but I can assure the court 100% that the jury will not be misled by my argument. And the boards are closing argument boards. They're not going back in the jury room. I'm very clear about that. And so I'm going to tell the jury that. This is based on all of the evidence, not just Mr. Diedrich. And I intend to make that very clear.
The problem is the boards themselves.
Your Honor, I don't think the court invited Mr. Neufeld to stand.
No, I was still having a discussion with Ms. Clark.
Sorry.
So
I see we're in fighting moods today.
It's argument. But in any case, Your Honor, the purpose of the board is to collate everything. And if I have to start fragmenting it again, I understood for testimony. And you know, I have no disagreement with the court's concern during testimony of saying exactly what the witness was saying. But now it's argument, and it's time to put it together.
All right, Mr. Neufeld, any brief response?
Yes, Your Honor. There are other boards where they refer to letters and other items of evidence are, in fact, statements of the actual record in this case. This is the one instance where they have it on a board that is not an accurate statement of the record in this case. It is distortion, it is misleading, and it is a board suggesting that that is, in fact, the evidence. And that's not the evidence. And they can modify that board. They can change the wording in it to reflect the state of the evidence, just as they have on the other boards. And it's actually disingenuous to suggest that, whereas there are other boards are accurate statements of the record, but this board I'll single out and I'll explain to the jury that I don't mean this to be a statement of the evidence, I just mean this to be argument. That in itself is misleading because it sets these boards apart from all the other boards they intend to use in their closing argument. It just isn't fair.
All right, thank you. All right, the objections to be overruled subject to modification during the course of counsel's argument, if it's not accurately argued. All right, how about the other exhibits? I just said it. You have it in real time.
The time these graphics were to be displayed to us, and we had people here this morning at 8 o'clock. It said 8 o'clock this morning. We're now seeing them at about 9:20 thereafter, so they're more than an hour and 20 minutes later. I point that out because of the fact that Mr. Harris came with our information regarding the clips we wanted to use, and he misunderstood the time. He had them in plenty of time. He always gets here at 8:30. Got here apparently somewhere between 9 and 10, as I understand it.
After 10.
I thought it was around before 10, but anyway, he said he's going to pollute. This is an hour and 20 minutes. We're just now seeing these. They went through very fast, and the court saw them, so I won't belabor this, but I want to point that out at the beginning. They should be precluded if we're to be precluded. If we're going to be able to use our clips, which we have here, it's the same thing. Your order, even if it's misunderstood. Theirs weren't ready. Ours was ready. It was a misunderstanding by Mr. Harris. But the point I wanted to make was that, for instance, on these boards and looking through them very quickly, and they went very quickly, this is the problem right before argument when they do this. They talk about a Bruno Magli shoe print, and they talk about the defendant's Bruno Magli's, I believe, at one point. There's no showing that Mr. Simpson purchased or bought any Bruno Magli's in this case. They have something on the defendant that did not go to his children. His children were brought to him. I mean, this is the most misleading kind of argument. If they want to use this, many of these things they're using at their own peril. I am warning them they're using it at their own peril. But the defendant did not go to his children. This photograph, I don't know the point of this photograph, this kind of time sequence photograph, kind of in a map or puzzle kind of fashion of Mr. Simpson. This idea of rejection by Paula, there's no evidence of rejection by Paula. There's testimony that Paula was at the Mirage being paid for by Michael Bolton, I believe, but there was no rejection by Paula. Using Cato to set up an alibi. I mean, this is just specious. In this, they use at one point the term consistent with, which is what you said they can do. That further highlights when she stands up and says, it's the defendant or the defendant's hair. I mean, that's misleading to this jury. This jury's not going to fall for this. They show the photographs of the officers. Risky never testified here in uniform. They have a photograph of him in uniform. I mean, so that what they're doing here, first they're an hour and 20 minutes late, beyond your order. They're tremendously misleading, and we need actually more time to actually look at these to see. This is just jotting down as we went through these very, very quickly. And it seems to me this is totally unfair and contrary to the spirit of what you were talking about. Now I contrast that with the video clips. The video clips, Your Honor, are exactly what happened in this courtroom.
I'm not listening to that argument, counsel.
All right, well, it's still the same thing. Well, then they get precluded then. If you're not listening to that argument, then under the same thing in fairness and an equal playing field, then these things get precluded. They weren't here on time, and so here now we're facing the situation. If you don't want to hear the argument regarding Mr. Harris yesterday, then it seems to me this should be precluded. I mean, clearly. You said 8 o'clock, it was clear.
Any other objections?
Well, it's really difficult, Your Honor. We saw them so fast for the first time. We really need to see them again. I need a little more time with them, quite frankly. That's all that I was able to jot down at that point as we looked at them together for the first time, an hour and 20 minutes later.
All right. Why weren't these things here at 8 o'clock?
They were. They were. Jonathan was here. He was here with all of the clips and the slides. They weren't ready. They were here. And we were ready to go. That's the answer. That's the answer. They don't have an excuse for this one. We were here. We were ready. They were not. That's it. With respect to the points on the slides, however, Your Honor, I've never had to preview my closing argument in any trial in my life. Those points on the slides are my argument. Now, unless defense counsel is going to be fair about this and give me their closing argument, I'll review it and I'll tell Mr. Cochran what I think is fair for him to argue too. Okay? If, as he says, the jury's quote-unquote not going to fall for that, then he shouldn't be concerned. The jury won't fall for that. I think that the jury's not going to fall for their stuff. I think the jury's going to fall for reason and logic, and that's what this is. But I don't have to make that argument now. The court's aware of these arguments. But those points up there are reasonable inferences to be drawn from the evidence. If the jury doesn't agree, if the jury thinks they're unreasonable inferences, the jury knows what to do, and they will do it. And
what about the in the triggering events board that you have there, rejection by Paula Barbieri, what's the basis for that?
During the day, I'll just trace it from the afternoon. This is based on the defendant's cell phone records. We have a phone call to Nicole at 2:30 in the afternoon, lasting for 4 minutes. Immediately after that phone call, we have 2 calls to Paula Barbieri, which were unanswered. As you recall, we had testimony from Kathleen Delaney. I think that's her last name. She was general counsel for the Mirage, and she testified to the fact that Paula had checked in to the Mirage on June the 12th at 1:59 p.m. So at the time that the defendant was trying to call her, she was already in Las Vegas at the Mirage, a guest of Michael Bolton. We also know that earlier in the morning or the previous day, Paula had asked to go to the recital with him, and he had told her no, that he was going to keep it a family event. We have our theory about what he intended in telling Paula not to go to the recital, which we intend to argue at the appropriate time. In any case, when he showed up at the recital, he was clearly, as the witnesses have testified, in a very unusual mood, glowering, spaced out, as Candace put it, simmering, I'm reminded, and whatever transpired in the phone call with Nicole at 2:30 in the afternoon clearly had something to do with that mood, in addition to the fact that when he went to the recital and the Mezzaluna date was made, he was not included. And he had already told Paula not to come to the recital. So essentially, and then he tries to reach Paula again later that night at 10:03, calling her twice when he was in the Bronco. Couldn't reach her at those times either. She was not there. So we know she was in Las Vegas. And I think that was the last straw for him. He was abandoned by Nicole. He was abandoned by Paula. And that's why we're here.
How about the Bruno Magli indication that this was his shoe?
Which,
One of the boards indicates the Bruno Magli shoe was the defendant's.
can we pull it up again so I can see, Your Honor? I'm not sure.
Let me see the next slide.
Is that what you meant, Your Honor?
No.
Next one?
I think the one that has to do with shoe print in the Bronco.
Okay. Yeah.
All right,
Yeah.
it says bloody Bruno Magli shoe print on driver's side carpet.
Yes, Mr. Boziak testified that there were characteristics in the print on the carpet that were consistent with the Bruno Magli shoe print. Would you like me to pull up the testimony? Okay. Can we call it?
This is a statement of fact.
Wait. Mr. Cochran's arguing this, counsel.
The only reason is he wasn't here earlier this morning. I thought I could just give the court a single.
Counsel, that was an indication to sit down.
I'm typing up the request right now, Your Honor.
Mr. Fairlow, what time did you have this laser disc here?
I had the laser disc here at 8 o'clock. I did a barcode check to make sure everything was correct. 2 or 3 of my barcodes were off, so I went back up to reprint so I could show them in the correct order. At that point, I came down, I believe it was a little bit around 9 o'clock.
When was that thing actually prepared?
I finished it up last night, at about 4 o'clock in the morning. I was still dropping slides to laser at 3 o'clock last night, and I was in the office barcode until about 4 o'clock.
I'm waiting for the testimony.
Yeah, it's going to take a few minutes. Is there anything else you'd like me to respond to?
It's the only 2 issues I've heard raised.
I'm really shocked, Ricky, that all of this stuff hasn't been worked out. There was a 3-day hiatus for arguments to be prepared by the lawyers, and certainly all of the support staff that each lawyer has beyond our conception to iron out all of the technological and auxiliary tools that were going to be submitted in support of these arguments. And I'm surprised that we're dealing with this, and I'm surprised that we're having arguments from the defense trying to preempt the prosecution's interpretation of the evidence. If, for example, as Cochran has submitted, that there's been a...
close to finding this?
a misinterpretation of the evidence, then it would be for him to point that out to the jury, and the jury would hold it against the lawyer that misinterpreted the evidence. But try to preclude somebody from putting something up in a demonstrative graphic to aid an argument, I think is surprising.
To get this. Is there anything else we can handle? Or I won't get to that part of my argument for a while, so we can start. And then I can make sure I get that to the court before we get to that point. It's going to be about 10 minutes.
Why is that?
Because
testimony off the system there and then bring it to court.
We can tell you what he said. We have it. We know what he said. He didn't say that. That's why they're never going to find it. There'll be 10 minutes and 10 hours. They will not find it.
well, if they have it, let's see it.
Do you have it?
He'll pull it up in just a minute. We know what he said. That he could not say they were Bruno Magli's.
The question that both sides are dealing with is the issue of the Bruno Magli shoes, and it goes back to the fact that sometimes you hear what you'd like to hear rather than what was really said. And the defense, as you can see, is going back through their transcripts trying to find the evidence. It's interesting, Howard Price, because in terms of the Bruno Magli shoes, the salesman from Bloomingdale's did talk about the fact that O.J. Simpson liked to shop at Bloomingdale's and did buy shoes there. But the question is, did he buy Bruno Magli's there? Now, the defense contends that he never said that O.J. Simpson was sold a pair of Bruno Magli's.
Watch.
All right, Your Honor, I think it was 32751, and I'll just try to read this. 32751. 5051. Okay. I could get any of the features in this enhanced impression to correspond with a silver sole, such as I had with the other comparisons that I made. And I was not able to take an overlay and actually reconstruct the exact position of that shoe to the point where I could say it was absolutely the silver design, and even go further and say it was the same. There just wasn't enough detail. And of course, it is not representing the normal design of the case, but it is just wherever there happened to be some blood up in the grooves and wherever the carpeting had to go up, it just randomly whipped down the. So this would be in the negative area, in the negative areas of the shoes, or the areas in the grooves, so to speak.
Your Honor.
Your Honor, I think that's they would never find it. It doesn't took 10 seconds. He can't say that, and they're still playing games, Your Honor, talking about they couldn't find it, and we found it right away. May I respond further to Your Honor?
No, Ms. Clark was in the process of telling me what the transcript says.
Yes, Your Honor. What the court needs to do is see the entire testimony. Counsel has only read, of course, a small snippet from an entire section of testimony. And my recollection, and I'm certain that I'm right about this, is that he testified, as I indicated to you previously, that there were features consistent with Bruno Magli's shoe print. Well, and that's what I said before. And it is in here, and I need time to find it.
Now the lawyers are dealing with another part of the Bruno Magli issue, which has to do with the expert's opinion of whether in fact these are Bruno Magli shoe prints or whether they're consistent with Bruno Magli's shoe prints. What about that, Howard Price?
Well, it's my recollection that the expert said it was a Bruno Magli, and that was never contested by the defense. In fact, I think that the defense expert almost conceded, I forget which one it was, conceded that it was a Bruno Magli. I think the issue always was, although it's a size 12, Mr. Simpson's shoe size, the shoe salesman never had a recollection of selling this specific shoe to Mr. Simpson. I always thought that was the issue, never that the shoe print found at the crime scene was nothing other than a Bruno Magli shoe print. In fact, the FBI man brought through all of his computerized prints, and he found it in his data bank to be a Bruno Magli, and I never thought that there was any cross-examination. If there were, I'm sure that Mr. Scheck would have been there for 2 days cross-examining him about the shoe print.
Or at least consistent, certainly, with the Bruno Magli shoe print. The question I've always had is the fact that once it's consistent with the Bruno Magli shoe print, even Marcia Clark has said repeatedly simply that O.J. Simpson was a candidate as someone who could have worn the size 12 Bruno Maglis. That was repeated, as I recall, by F. Lee Bailey in his original cross-examination of Special Agent Boziak when he appeared the first time. And now you can see, as all of these lawyers are looking through this transcript, the difficulty that jurors must have when they have to try to come to a consensus of 12 people as to what certain facts were in the case. Here you have the lawyers in the case who can't come to an agreement.
What's really interesting here, and I've never seen this happen, is a preemptive attempt to censor the other party's argument before it even begins. And that's a very sharp tactic for sure, but I've never seen it happen. Most judges would say that the jury has the ultimate decision as to what the evidence is.
Counsel left off at the portion where he read, or the areas in the groove, so to speak. And then the testimony was, yeah, I did notice that there was this area here which could possibly have been a border of the shoe. And there also is some little, what I call squiggles or little S shapes, which might represent the curved areas between the design elements. But they weren't clear enough or reliable enough to make any kind of a positive determination. And then can you point out the areas? And no, the upshot of his, there's more testimony on this, but the upshot of the testimony was, okay, and now he's referring to the actual carpet, and he said, okay, this area here was the area that I referred to that might be the border of the shoe, and this area down here where it changes direction, kind of like an S, is an example of that possible, the negative area of the shoe. And then can you take the rubber shoe, and that was the exemplar that he had, Your Honor, and describe for us how it is that that is possibly consistent with the sole of the Silga? Yes, well, I don't know how well this can be seen with the light, but if you follow the grooves between the design elements, they change direction. So there is gentle curves between those design elements. And that would be the area that would be, still might be some blood in it at that point, back down the driveway, that far from the actual crime scene. And these little changes of directions that you can see down here, as well as this border, and you really can't see any of them clear enough to make an overlay, but you can see something that suggests that. But there's just not enough detail to absolutely say that that is representative of the Silga sole. Okay, were you going to point out a couple of other of these design elements that were consistent with this sole? No, I think that these in here probably show it as well as any. And actually there isn't enough clarity throughout this whole thing to really point to it and say positively that is what it represents, but rather you are seeing a change of direction, and that is what you would expect if there was some blood here and the carpet tuffed up.
Ms. Clark, when do you
phenomena...
anticipate getting to this exhibit or this demonstration slide?
Let me see. Not for a while, Your Honor. That's why, we can... I mean, I think that the testimony does clearly indicate he's saying it is consistent. He's not making a positive determination, because there's not enough clarity for him to absolutely positively say it's a Bruno Magli. We are making inferences, Your Honor, because we have Bruno Magli shoe prints going down the walkway and a bloody shoe print with features like it on the driver's side of the carpet. I think it's only a reasonable inference that it is the Bruno Magli shoe. It's not only a reasonable inference, it's an obvious inference. So what he said was it was consistent with, but he would not make a positive determination.
All right, thank you.
May I respond, Ivan?
Yes, two issues, Mr. Cochran, specifically responding to the two objections that you made, the triggering events issue and the Bruno Magli issue that we just finished discussing, and the second issue being an opportunity to see all of these.
Thank you. Let me take the second issue first. The court asked Ms. Clark when would she get this in her argument. She should never get to this in her argument. It's the exact same thing. This court has prided itself on being fair, I think, to both sides, or trying to be fair to both sides. Yesterday you precluded us from something that everybody knows about because it's something that happened during the courtroom, and we were only to give actually the text passages, the quotes, not even view and show and tell, which we're prepared to do, which we worked all night to do. In this instance, what Mr. Blumenfeld was trying to tell you, Your Honor, that at 10 minutes to 9 he spoke to you and told you they had not shown him this show and tell at that point, because Mr. Fertlow was not back down here. It didn't work at that point. There was a glitch. So it was, as we said, an hour and 20 minutes after your order. So under that reasoning, I mean, this is a real easy one. They are precluded from doing this. If we take those kind of positions, it has to be for both sides, not just for the defense.
Well, Mr. Cochran, on the 22nd, late in the day, Ms. Chapman asked for an extension.
Yes.
I said yes until 9 a.m.
Yes.
All right. 9 a.m. came and went. Nobody showed up. At which point, at 9:30, I issued that order.
May we heard on that?
So there were two chances, two opportunities.
Your Honor, it's something that's important. We asked for the extension, and let's make clear what we're talking about here. What you'd ask us to do was to provide by 9 o'clock yesterday with a list of the items we wanted to do. Not even the items, because that takes an awful lot of work. Mr. Harris misunderstood that. Mr. Harris is always here by 8:30. Certainly Mr. Harris didn't do that intentionally. He would never do that. He's always here every day. He's been here from Florida for a year and a half, and certainly he would be here on time. But the point is this, Your Honor, if I might just say this, if you allow me. Mr. Harris not getting here, being a half hour, an hour late on just the actual quotes, that should not inure to the detriment of O.J. Simpson. That's unfair. And so what should happen, if you want to sanction Mr. Harris or sanction us, then do that, but not Mr. Simpson. Now, let's put it in perspective here. The reason, this is far different. This is actual text that we need to see so the jury, the 14 people back there, don't have to spend this time. You said 8 o'clock. We had people here at 8 o'clock. They weren't ready at 8 o'clock. Ms. Clark again has been caught. They weren't ready at 8 o'clock. At 9:20 they were ready, just like she makes this statement here about the bloody Bruno Magli shoe print. You know, sometimes we have to have some credibility in this courtroom. So those are the facts, Your Honor. So I know you said you didn't want to hear this, but you're a wise man, and you have been fair in the past. If you look at this, well, how can we look at O.J. Simpson and say because Howard Harris didn't get a text down here, that everybody knows what these clips are, it's actually the trial testimony, that O.J. Simpson should suffer from that? Mr. Harris is very sorry about that, if he got a chance to talk to you about it. But that's just not fair, Your Honor, in the circumstances. Now, we have a situation here where they come down. They don't come at 8 o'clock. Neufeld tells you at 10 of 9 we haven't seen it. At 9 o'clock when he comes back, we still don't see it. We have to ask to see it, and it's 9:20. And you can now see why we don't get a chance to see it, because it has all these things on here. Now, that moves me to the other point you asked me to discuss. The bloody Bruno Magli shoe print on driver's side carpet. Now, Judge, she can argue all she wants. The evidence does not show that. That's a lie. The evidence doesn't show that. She can talk about reasonable inferences, which she would like to hope. But this just shows the desperation of the prosecution. At this 11th hour, they would try these tricks. And they're tricks, Judge. These are nothing but tricks. It's not going to work, but I don't think we can be part of this at this 11th hour. So, to be fair, this has to be precluded. This has to be kept out because they didn't have it here at 8 o'clock. We didn't get a chance to see it. We're prejudiced by this, even as we're arguing now. There are other things that went by so fast, I'm not totally clear on all the things that were there. I happened to pick up bloody Bruno Magli shoe print because I knew that wasn't true. But the other thing that I think you allowed me to talk about is this whole issue of Paula Barberi. I mean, that is the rankest kind of speculation. Paula Barberi stands by this man's side to this day. There's no indication there was ever any rejection. In fact, quite the contrary. They'd made plans for later that week. I mean, it's just the evidence is replete with the fact that she was totally supportive. And the testimony, I think, of the young lady, Carol Connor, on the Saturday night, June 11th, when O.J. Simpson takes the pictures with the elderly women at the $25,000 plate dinner, they were absolutely lovey-dovey. On Friday, until Paula went to prayer meeting. I mean, it's all to the contrary. This is their fantasy, their whole case. We should have known when the ship thing came up. This is all about their dreams. And it's not going to work, Judge, but we can't be part of that. So this is unfair. And it just seems to me that they are precluded. Now, we're not saying... I would ask Your Honor to consider this, but under your ruling yesterday, they're precluded. I mean, quite simply, it wasn't shown, and this is far more different than just telling you generally what we expected to show in clips, things that you've already seen during the course of this trial. May I have a second here? And I'm reminded by my colleague, there's a far different. Yesterday, what we're going to give you is the page and line number of things we wanted to show. And you also made it very clear, and that's why you see Mr. John Whitney here. We could not show the face of, say, the defendant or the lawyer asking the questions. So in going through all this, we had to black all that out, and that took a lot of work, as I said. But there was no prejudice to them, and I trust not to Your Honor, because it was a question of what had happened in this courtroom. We're talking about a search for truth. This is a lawyer's interpretation of what they would have hoped the evidence would be. There's much more prejudice to us an hour and 20 minutes later when she's about to stand up and argue, for them to show us this in this rapid-fire discussion. We're talking about prejudice, and it's prejudice to Mr. O.J. Simpson, Your Honor. And so that I would say to Your Honor two things. These should be precluded.
All right. What's the people's position on the videotape issue?
May I add another page to the Bruno Magli issue, Your Honor?
No, I'm not interested. I've heard enough on that.
Yeah, just a second.
There's a final conclusion that he makes on it.
I recollect, counsel. I have my notes.
The court
Mr.
ruled
Cochran is arguing a sophisticated version of tit for tat.
that we be precluded from my argument.
Yep.
I don't see that is tit for tat, Your Honor. They wanted to use, the court made a very specific ruling. The court did not say counsel is required to submit their closing argument to the opposing counsel for editing ahead of time. Court ruled that if we wanted to use video clips, they had to be, or I thought it was just the defense, but that if video clips were to be used by the defense, they had to be submitted to the court by a time certain, and that if they weren't, they wouldn't be allowed. Isn't that a little different than what I'm allowed to argue to the jury? And we're talking substance here, because all those are the words that I intend to argue. We're not talking about a slide, involving a picture of something. We're not talking about videotape, because the use of videotapes in argument is a very novel thing. So understandably, the court was concerned that it'd be allowed to preview what counsel wanted to use, because it is an avant-garde kind of thing to do. I don't know if it's ever been done before. And the court needed to assure itself that what was done was appropriate ahead of time. But arguing reasonable inferences from the record is something that had been done for hundreds of years, Your Honor. I'm doing nothing different. That's all I'm doing, is making it easier for the jury to see, just like we did in the old days when we had an easel and we'd get up there and write all the reasons why the defendant was guilty. Okay, so now we have this whiz-bang stuff and I can do it on a screen, but that's the only difference. I have a witness that says it's consistent with this, but I can't positively say. I draw reasonable inferences based on all of the evidence and tell the jury, but we know it is. Now, is that something new and different that a prosecutor does? I'm not doing anything different. I'm just using a screen instead of an easel to do what we've been doing for hundreds of years. So this is not tit for tat, Your Honor. Counsel's so scared, he's saying, don't let her argue. Don't let her draw reasonable inferences. Don't let her pull this together for the jury. That's what we have here. I'm drawing inferences from the evidence, and I'm arguing the evidence. He wants to use something novel that the court wanted to safeguard. I understand that. Mr. Fairtlow was down here at 8 o'clock. Sherry Lewis was down here at 8 o'clock. They weren't ready. They were looking at the boards. Peter Neufeld had broken his glasses. They weren't ready to see anything. We were here.
That's contrary to what Mr. Fairtlow has just said, Your Honor. And Ms. Clark has not answered.
To fix a few barcodes, but if they had been ready to sit here and watch it at 8 o'clock, he would have shown them what we had.
These are officers of the court. They were ready. That's why they were here, Your Honor.
Let me finish.
Wait,
Mr. Neufeld.
wait. Argument's over. I've heard enough. Thank you very much. It's been entertaining as usual. All right, the defense is entitled to see these, since they're going to be used during the course of argument prior to their use. We'll take a 20-minute recess to allow that to occur. Mr. Fairtlow was, in fact, here this morning at 8:05, because I did come out and see him seated back there, and he was playing with barcodes. We did look at the charts that were physically here, and I did use members of my staff to go down and get crazy glue for Mr. Neufeld to fix his glasses, and that was what was occupying us for the most part. Previous ruling stands regarding videotapes. The court finds that as far as the argument is concerned, there are inferences. What a prosecutor is allowed to do is to discuss the evidence and then draw reasonable or plausible inferences from that. I agree that perhaps some of these may not be logical, but it is argument.
Is that videotape on both sides, Your Honor?
Videotapes on both sides is precluded.
The court, may I say one last thing in that regard?
No. That's the end of that argument. All right, we'll take 20 minutes to show them the exhibits.
If we have objections, do we bring those to your attention?
Counsel, it's argument. I've seen them all. Show them. All right, 20 minutes.
I'd just like to make a general objection, if I might. These slides are totally misleading. There's a whole list of things. I won't even bother the court's time now. They're totally misleading. And to allow this jury to hear this, it just shows the prosecution's desperation. But we could point out chapter and verse, but it's not going to do any good. So I thought that I would just register a general objection. This, I think, is totally outrageous. The other thing I'd like to point out to the court is that we have some graphics which are not precluded, and of course we have evidence items that are in evidence which we can still show during the course of this trial. Because of the fact they weren't ready this morning, they've not seen ours, so I'm going to ask that we be able to do that before we start our case. Plus, we will obviously now be responding to these lies on these boards and try to tell this jury some measure of truth. So am I correct? We can do that also? As I noted, one uses these things at one's peril. Yes, you did say that, Your Honor. So we'll be doing that, and I'd like before we begin our case if the court wants us to, we'll review it or not, but we're ready. If they want to go with this now, you've noted my objection? Noted. Let's get it on. Thank you, sir. Yes.
All right. If I could just indicate this, they have shown us one board, Your Honor, one defense board. It's the thermometer involving reasonable doubt, that's standard. I just want to lodge an objection to that now. We can argue it before the defense argues.
We'll get there eventually. All right. Deputy Trower, let's have the jurors, please. We are at that stage where the attorneys will have the opportunity to argue to you. And I should let you know that previously I had contemplated placing a time limit on the lawyers in their argument. Some of the factors that I considered in whether or not I should place a time limit on them was the quantity of the evidence that was produced, the conflicts in the testimony, and the complexity of the issues that you'll have to resolve. And after considering the length of the case and the nature of the evidence, I have decided not to place a time limit on the argument of the attorneys. However, I have placed upon each side a limit of no more than 2 attorneys may argue to you for this part of the trial. Now, the purpose of the argument by the attorneys is to discuss with you the facts and the evidence that have been presented to you, to discuss the law that I instructed you on earlier, and the attorneys may advance theories based upon the evidence, and they may urge conclusions that are fairly drawn from that evidence. However, during the course of their arguments, please remember my previous admonition to you that the comments and argument made to you by the attorneys are not evidence. All right? Having said that, Ms. Clark, on behalf of the people or the prosecution, prepared to proceed their opening argument.
Yes, Your Honor, we are.
All right, you may proceed.
Thank you very much. Good morning, ladies and gentlemen. Finally. I feel like it's been forever since I've talked to you. It kind of has. It's very weird to be in this courtroom next to you, seeing you every day, not getting a chance to talk to you. It's just very unnatural. And I have to tell you that as long as I've been doing this, as many years as I've been doing this, at this moment in a trial, I always feel the same. I feel like I want to sit down with you and say, what do you want to talk about? Tell me what you're thinking.
Ms. Clark, I'm sorry.
You want a pen, sir?
Juror 165 needs a pen. Ms. Clark.
Thank you, sir. I want to sit down. I want to talk to you. I want you to tell me, what do you want to know? You know, what do you want to talk about? Because that way I don't have to talk about stuff that you don't need to hear, stuff that you don't want explained, stuff that you're not interested in. And I can't. And I always have this sense of frustration. So I'm sorry if I say things that you don't need to hear or explain things that are already very clear to you. Please bear with me because I'm not a mind reader and I don't know. Let me first, I want to take this opportunity to thank you. And I want to thank you from the bottom of my heart. You have been through so much. You have made a tremendous sacrifice. You haven't seen your children enough. You haven't seen your family enough. You haven't seen your loved ones enough. And all of this in the name of justice, in the service of justice. Your dedication and your selflessness are truly beyond the pale. No one can say that any jury has sacrificed more for the cause of justice than you have. And I want you to know sincerely, from my heart, I appreciate it. I speak on behalf, I know, of the people of the state of California. This was a tremendous sacrifice. Your selflessness and your devotion will long be remembered by many. And I thank you. I think no one can understand how great your sacrifice has been, how terrible the pressure has been, how awful it must be for you to have your lives kind of out of control this way, at the mercy of us taking longer than we should have, and you having to put your lives aside for longer than you should have had to do. I'm sorry for that. I apologize for that. There's only one bright side, 2 bright sides. One, it's almost over. Number 2, you have the assurance of knowing that no stone has been left unturned. The defense has explored every nook and cranny of the case. We have exhaustively tried to give you every piece of information that could possibly be relevant to answer the question we're here to answer. And in doing so, in the exhaustive examination and cross-examination of all of the witnesses in this case, and the exhaustive investigation and work that's been done, one thing is clear. This defendant has received the ultimate in a fair trial. And at least you know that. You have that assurance. Now, in the course of presenting all of this evidence, in this trial, just like every trial, some evidence has been presented to you that really is not relevant to answer the core question of who murdered Ron Goldman and Nicole Brown. And it's up to you, the jury, to weed out the distractions, weed out the sideshows, and determine what evidence is it that really helps me answer this question. And it's kind of like the artist and the sculptor. Somebody went to him and said, well, how do you make an angel? Well, I take a piece of marble and I remove everything that's not an angel. That's what you have to do. It's not easy. It's going to require a lot of focus and a lot of determination on your part, because the sideshows may be very interesting. They present very important issues, very serious issues, but issues that really do not relate to who committed these murders. And they should be dealt with outside this courtroom, because here now, in this courtroom, we're here to decide who murdered Ronald Goldman and Nicole Brown. Now, you as jurors sit as judges of the evidence. You're called the trier of fact. And as such, your job it is to be neutral and to be impartial as you examine the testimony presented. And in this regard, you're guided, just like any judge, by the law. And the jury instructions that were read to you on Friday is the law that you will apply to the evidence to determine the answers to the question that is posed here. Who murdered Ronald Goldman and Nicole Brown? The instructions discuss a wide range of topics. They talk about guidelines for the determination of credibility of witnesses, both expert and lay witnesses, and they talk about what the people are required to prove to establish the defendant's guilt. But they go beyond that, and they also tell you the frame of mind that you should adopt when you look at all the evidence. And one of the first instructions that was read to you by the judge on Friday, if you'll recall, concerned your duties as a jury, and it stated in part, you must not be influenced by pity for a defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with a crime, or brought to trial. Now, of course, that makes sense. It's logical. And that means that we have to present proof to you. We can't just come in and say it so. Why don't you get up here and say it so? I have to prove it to you with evidence beyond a reasonable doubt. So that makes sense. Now, the instruction goes on to read, you must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the people and the defendant have a right to expect that you will conscientiously consider and weigh the evidence, apply the law, and reach a just verdict regardless of the consequences. In the course of this trial, you have heard some testimony of a very emotional nature. I expect that in the course of arguments you're going to hear very impassioned speeches, fiery speeches, speeches that may stir up feelings of anger, sorrow, pity. Although your feelings may be aroused, as would be natural and understandable for all of us. As the instruction tells you, as the trier of fact, you, the judges, are to remain neutral and impartial and not be influenced by such passion or sentiment, no matter how sorely tempted you may be to do so. And this applies to both sides. Both sides. Although the brutal and callous way in which Ron and Nicole were murdered may understandably make you feel sorrow, pity, even anger, it would be wrong to find the defendant guilty just because you felt sorry for them. On the other hand, although it would be completely understandable if you were to feel angry and disgusted with Mark Furman, as we all are, still it would be wrong to find the defendant guilty, not guilty, just because of that anger and disgust. So as you listen to the arguments of counsel, please remember, when you weigh the evidence and you consider all of the evidence, remember that an appeal to passion and emotion is an invitation to ignore your responsibility as a juror. To be fair, we must examine all of the evidence in a calm and a rational and a logical way. And let me come back to Mark Furman for a minute, just so it's clear. Did he lie when he testified here in this courtroom saying that he did not use racial epithets in the last 10 years? Yes. Is he a racist? Yes. Is he the worst LAPD has to offer? Yes. Do we wish that this person was never hired by LAPD? Yes. Should LAPD have ever hired him? No. Should such a person be a police officer? No. In fact, do we wish there were no such person on the planet? Yes. But the fact that Mark Furman is a racist and lied about it on the witness stand does not mean that we haven't proven the defendant guilty beyond a reasonable doubt. And it would be a tragedy if, with such overwhelming evidence, ladies and gentlemen, as we have presented to you, you found the defendant not guilty, in spite of all that, because of the racist attitudes of one police officer. It is your duty, and it will be your challenge, to stay focused on the question you were brought here to answer. And the only question that you were brought here to answer: did the defendant commit these murders? In seeking the answer to this question, you look to all of the evidence presented to you by both sides now, by both the people and by the defense. And you determine what evidence really answers that question. Because the defense has thrown out many, many other questions. They've thrown out questions about whether LAPD has some bad police officers. Does the scientific division have some sloppy criminalists? Does the coroner's office have some sloppy coroners? And the answer to all these questions is sure. Yes, they do. That's not news to you. I'm sure it wasn't a big surprise to you. But they're important issues. You know, we should look into the quality control. Things should be done better. Things could always be done better in every case, at every time. There's no question about that. We're not here to vote on that today. The question is what the evidence that was presented to you that relates to who killed Ron and Nicole, what does that tell you? Does that convince you beyond a reasonable doubt? No matter how much more qualified or how much better they could have done their job, still in all, did they present enough evidence to you? Did the evidence come to you in sufficient quantity and convincing force to convince you that the defendant committed these murders beyond a reasonable doubt? Ladies and gentlemen, I submit to you that we have more than met our burden in this case. Now, the defense has thrown out a lot of possibilities to you, the merest of possibilities. And a lot of them were just there to scare you. You heard Dr. Gerdes talk about it could be this, it could have been that. I see the validation studies, you know, kind of like, reminds me of the doctor when you have to go in for an operation, they give you all this list of things that could possibly happen to you. Could possibly happen to you. Nevertheless, and they have to give you that warning, right? They got to tell you that, because otherwise you cannot give an informed consent and say, yes, knowing the risk, I'm going to go and do this. Now, if you really believe that all these horrible things are going to happen, no one had an operation. You wouldn't take the risk. But you know, they've got to tell me everything, no matter how remote the possibility. And indeed, you go and you have the operation and you're fine. And none of that stuff happens. Well, in this case, it's actually, they've raised all the possibilities of things that could happen in an effort to scare you away from the evidence. But we have done better than you could ever do in an operation, because we have proven to you that nothing in this case did happen. We have proven to you that it was not contaminated. We have even proven to you that it was not planted, for lack of a better term. And I'm going to go through the evidence and demonstrate how we have proven that to you. So why were these issues raised? Why were these questions raised? Well, they are all questions and issues that were raised as a distraction. They were roads created by the defense to lead you away from the core truth and the issue that we're searching for the answer to, which is who murdered Ron and Nicole. But these roads, ladies and gentlemen, these are false roads. They're false roads because they lead to a dead end. The false roads were paved with inflammatory distractions, but even after all their tireless efforts, the evidence stands strong and powerful to prove to you the defendant's guilt. Now, I'd like to show you a jury instruction that is very important. I think that both the prosecution and the defense will agree. Reasonable doubt. Okay, this is an instruction that we'll talk to you about, they're going to talk to you about. This is a real important instruction. It's at the real heart of a case, every criminal case, because it's the burden of proof that the people have. We don't guess anybody guilty. We prove it beyond a reasonable doubt, which is what we've done in this case. Now, this tells you about reasonable doubt. It's kind of a funny definition, because it talks to you about reasonable doubt in very negative terms. It says that state of the evidence, which after the entire comparison, you cannot say that you have an abiding conviction. It's very weirdly worded. It's going to take you a while to go through this, so I'm going to go through pieces of it at a time to try and give you a little hand here. First of all, let me point out, the first paragraph talks about the fact that it's our burden of proof. I think that one's fine. That's pretty easy. Now it talks about how reasonable doubt is defined. This is real important. It is not a mere possible doubt. Okay? Because everything relating to human affairs is open to some possible or imaginary doubt. That's very important. is a doubt founded in reason. I'm going to amplify more on that with examples when we talk about the actual evidence in this case. But bear that in mind, a possible doubt. I have a possible doubt that the sun will come up tomorrow. Do I have a reasonable doubt about it? No. I have no doubt founded in reason that that's going to happen. Just for a very basic example. So think about that too. We're not talking about what possible doubt is. It's reasonable doubt. Now the other part of it, it is that state of the case which, after entire comparison, the entire comparison and consideration of all of the evidence. Now what that means, ladies and gentlemen, is you consider the defense case and you consider the prosecution case. You consider all of it. You'll probably hear from the defense multiple times, we don't have to prove anything. That's right, they don't. In every criminal case, when the people complete their presentation, the defense can say, no witnesses. We rest. Because they can sit and make the state prove their case without ever calling a witness. That's right. That's correct. But when they do, then you must consider the quality and the nature of the evidence that they have presented. That goes into the mix. That's part of your consideration. What kind of evidence did they present to demonstrate something to you, to prove something to you? If they try to prove something to you, their witnesses, their evidence gets evaluated by the same rules ours do. The same jury instruction applies. You will see a jury instruction in your packet back there that talks about how to evaluate the credibility of witnesses, both expert and lay witnesses. There is no distinction made in that jury instruction for defense witnesses or for people's witnesses. It's all the same. You determine their credibility and the relative convincing force of the proof by the same rules. Okay? So that's the first thing to remember. When you look at everything, you look at all of it. What have they shown you? What have we shown you? We have the burden of proof. But you look at what they've shown you when you want to consider what was proven to you. We got pieces of boards and exhibits everywhere in this courtroom. All right, now, all I'm telling you, ladies and gentlemen, is it's reasonable doubt and it's not possible doubt, and we'll come back to it again. But at the conclusion of all of our arguments, when you open up the windows and let the cool air blow out the smoke screen that's been created by the defense with a cool wind of reason, you will see that the defendant has been proven guilty easily beyond a reasonable doubt. Or to put it another way, the evidence has conclusively proven that when Detective Mark Furman said he did not use racial epithets in the last 10 years, he lied. But it has also conclusively proven that the defendant is guilty beyond a reasonable doubt. Now, I'd like to start with the evidence in this case with the timing, okay? I think that's the easiest place to start. The timing on June the 12th. Let's begin with a very brief review of the movements of Ron and Nicole, and we're going to start with the recital in the late afternoon. I'm sure you recall that recital for Sydney at Paul Revere High School. Nicole left the recital and went to the Mezzaluna restaurant near her home along with her parents and some friends and her children, Sydney and Justin. And she arrived at the Mezzaluna at approximately, I think it was 6:30 p.m. Ron Goldman, who was an acquaintance of hers, a waiter at the Mezzaluna, was working that night but did not wait on her table. And when Nicole and her family left between 8:30 and 9, they didn't know that the simple act of dropping a pair of glasses would have the tragic consequences that we all know now that it did. Now, you recall at the end of the People's case there was a stipulation that we entered into, and you recall that the judges told you that a stipulation is to be accepted by you as an undisputed fact. And the stipulation told you the following. After leaving the Mezzaluna that night, Nicole's mother called the Mezzaluna to ask about her glasses. That was at 9:37. Karen Crawford, the bartender and Sunday night manager of the Mezzaluna, took the call and went out to look for the glasses. She found them outside near where Nicole had pulled up in front of the restaurant, and at Mrs. Brown's request, she put the glasses into an envelope on which she wrote, I believe she wrote, Nicole Simpson will pick up Monday. That call lasted 2 minutes. It was also stipulated that at 9:40 p.m., Mrs. Brown called her daughter Nicole, and they spoke for 2 minutes. And in that last conversation, before her death, Nicole promised her mother that she would arrange to pick up the glasses. Now, those 2 conversations with Nicole's mother were a matter of stipulation. That's an undisputed fact. Karen Crawford testified that about 5 minutes after speaking to Nicole's mother, she got a call from Nicole. That would mean Nicole called her at about 9:43. Nicole asked to speak to Ron. He took the phone, and after Ron spoke to her, he asked Karen for the glasses. She gave him that envelope containing the glasses. And at about 9:50, 10 of 10 that night, Ronald Goldman left the Mezzaluna restaurant. When he left, he was wearing the white shirt and dark pants that were part of his waiter's uniform. And that uniform was later found by his sister, Kim Goldman, in his apartment, draped over the bedroom door. That uniform is here in evidence. So we know that Ron went home and changed clothes after he left the Mezzaluna at about 9:50. The other waitress in the restaurant, Tia Gavin, testified that it takes about a minute to walk from the Mezzaluna to his apartment. So, even being a little generous, he got home by about 9:52, say. He changed, he freshened up, because we know he wasn't wearing that waiter's uniform when he was found. And so it would be reasonable to infer that he got to Nicole's house with the envelope sometime shortly after 10. And when I say sometime shortly after 10, we don't know exactly what time, and I'm not saying that we do, but 10:10 or so would seem a reasonable amount of time to get freshened up, changed, and get over there, based on what we do know. Now that brings me to something else that I want to point out. In the case, as in every case, there is certain evidence that is introduced that is directly proving a fact. For example, in this case, Ron Goldman left Mezzaluna at approximately 9:50. It's approximate time. Could have been a few minutes later. So we know that sometime before 10 he left. We know he changed clothes, okay? But the direct thing we know is that sometime shortly before 10 he left. We know he changed clothes because he was wearing something different when he was found. We know how long it takes for him to get home because we have a witness telling us that, but we don't know is exactly what time he left his house. We know he left his house in time to be murdered, and we'll talk about that shortly. And in time for him to be there with the dogs barking, we have to make inferences. Okay, we have to make an inference from the evidence that we know about as to when he got to Bundy. Now, you can draw an inference that is reasonable, or you can draw an inference that is unreasonable. What we are required to do here, and what I must do, is draw inferences that are reasonable. Based on what we know, when he left the Mezzaluna, changing clothes, freshening up, and I think Stuart Tanner testified that they had plans to meet at the Baja Cantina. He was going to get cleaned up to go somewhere. It's reasonable then to infer that he took 10 minutes or so to do that, change clothes, freshen up, and then go over to Bundy. Now the dogs. Excuse me, the witnesses that testified to the dog. As you may recall, we heard from a number of them, and they were neighbors of Nicole. Now, as for the people that the prosecution presented on this issue, all of these people were people who lived very close by. All of them were people who were home on that night, and all of these were people who were not distracted by anything else going on at the time. And all of these were people who did not seek out involvement in this case. All of these were people who were found by the police during normal police procedures as they went knocking around the neighborhood doors to find out if anybody heard or saw anything. And some of these people were disturbed by the police at 2:30 in the morning, at 5 in the morning, and these people just were summoned by the police to tell what they heard, what they saw. They didn't go out looking for their 15 minutes of fame. They didn't go calling the police and running after the detectives to try and tell them they knew something important so they could be on TV and become the latest sensation. These people were called upon by the police because they were there. They were near her. They were close to the condominium. They were within range where they might have seen or heard something, and so they were contacted. And so they were subpoenaed. They didn't ask to be involved. And that's a big distinction between our witnesses and the witnesses called by the defense on this issue. Now, the significance of the barking dog is obviously that it tells us roughly when the murders occurred. Not exactly, but it's reasonable to infer, again, reasonable inference, that the murders occurred either shortly before or during the time when the dog was barking. Now, the neighbors who testified to this said that they had not heard a dog barking so insistently like that before. It really drew their attention. That's why they remembered it. It's why it woke them up or disturbed them or made them concerned, made them look out their windows to see what was going on, because it was unusual. Which means that Nicole was not in the habit of letting her dog run around like that. Which means that if that dog is barking like that and she's not tending to it, she's already dead. Now, what did they say? The witnesses that we presented were very consistent in this regard. I'm going to show you. Now, I'm going to direct your attention down here. Okay? The first witness that we called was named Pablo Fendes. You may recall that he testified he was in his apartment on that night, and that at approximately 10:15 to 10:20, he heard the insistent barking of a dog. He called it a plaintive wail. And the nature and sound of the barking that he heard made it sound to him like it was a dog in trouble, like something traumatic had occurred. And it drew his attention, made him think about what was happening, and he noticed it. He noticed it, and he noticed the time because he'd been watching the news. And so he tied the time to that event. And he testified it was between 10:15 and 10:20, approximately, that he heard that. We called also, and you see he's right here on the timeline, Mark Storfer testified as well. Now, let me back up, I'm sorry. Pablo Fendes was the one who lived behind the condominium, diagonally behind Nicole Brown, across the alley, if you'll recall. His windows, he had windows that faced the alley, and at one point I think he pointed out where he was able to see. And he indicated that the barking seemed to come from the location of Nicole's condo. So he lived right behind her. The other witness who testified was Mark Storfer. Mark Storfer lived down on Dorothy. That would have been just south of Nicole's condominium. Mr. Fairlew, do we have the dog board that we had showed with the witnesses where they lived? Is that down here? Oh, I'll get it. That's fine. That's fine. Here, the red house here that I'm pointing to is Nicole Brown's house. This purple house right here, south on Dorothy, that is Mark Storfer's house. And he testified, if you may recall, that he was just putting his little son to bed when he heard the dog barking. And he was concerned, and it drew his attention because he was worried that the dog was going to wake up his son. You know, I think a lot of us know what that's like. We finally get the baby to bed, and then something happens to wake it up. It's horrible. And that's what happened to him. So he was very cognizant. He was very aware of the fact that dog was barking, and it was disturbing him. He went upstairs, and approximately, he said, 2 to 3 minutes after he heard the dog start to bark, went up and looked at his clock, because he was concerned how late the hour was and why the barking was so loud at that late hour. He looked, and he looked at his clock, and it said 10:28. Now, he said they always keep their clocks 5 minutes fast. So his clock really, this gets complicated, really said 10:23. Since he heard the dog start barking 2 to 3 minutes before he looked at the clock, it was approximately 10:20 to 10:21. Now, he also lived very close. And what's important for you to know and recall about his testimony is that when the dog started barking, he indicated that he looked out his window at 10:23. A few minutes after the dog started barking, he went to see what was going on. And the source of the noise seemed to come from north of him on Bundy, which is, of course, the direction of Nicole's house. And when he looked out the window at 10:23, he saw no one walking down the street. That's real important. I'd like to ask you to try and remember that fact. Mr. Darden will discuss how significant that is when he speaks to you later. We also heard from Eva Stein and Louis Karp. They were the next door neighbors of Nicole Brown. This is the blue house here. They live right next door. Now, on that night, Eva Stein had gone to bed shortly before 10 o'clock. And at some point, she indicated shortly after she fell asleep, she was awakened by the loud, insistent barking of a dog. Or she thought it might even been more than one dog because it was so loud. She indicated that shortly after that, approximately half hour later, after she started to hear the barking dog, her boyfriend, Louis Karp, came home. And she could tell that he came home because she heard the bell. So half hour after she heard the dog barking, he came home. And Louis Karp told you he came home at 10:45, 10:50 at the latest. Which means that she heard the dog barking also at 10:15 to 10:20. Now, and just to remind you, Pablo Fenbez's house is the yellow one indicated here on the board. So just across the alley behind Ms. Brown's condo. All right, now, Louis Karp also told you something else. He told you that when he came home, he went into his garage, and then he went out in front to get the mail. And when he went out in front to get the mail, he saw a dog in the street. And this was the time he indicated that he got home. When he got outside, he saw a dog running around in the street, barking insistently. A dog that he identified for you as Cato, Nicole's dog. The dog was prancing around in the street and acting in a very weird manner, and Mr. Karp was a little afraid of him and went back inside. Now, Mr. Karp also told you that he saw a man walking a dog. Steve Schwab told you that at about 10:30 he left his home and went out and took his dog for a walk. If you recall, he said that he waited to see the end of the Dick Van Dyke Show and then went out to walk his dog. That was about a little after 10:30. He told you of the route that he took, walking around the neighborhood, and he told you that at approximately 10:55, he saw Cato, Nicole's dog, at the corner of Dorothy and Bundy. And he told you that the dog was acting very strangely. So he went over to look at the dog. And when he did, he noticed that the dog had blood on its back paw, and the blood appeared to be moist. He crossed over to the east side of Bundy where he said the lighting was better. In other words, saying to you that the side of the street that Nicole lived on was poorly lit. Now, he noticed that the dog's paws had blood on it, but he did not testify that he saw any paw prints on the sidewalk. Does that mean that they weren't there? No. It means he didn't notice them. Obviously, if the dog had blood on its paw and it had gone out of Nicole's home and it had walked down the sidewalk, there were paw prints there to be seen. The fact that someone doesn't see something doesn't mean it isn't there. It means they didn't see it. That's what I mean about reasonable inferences to be drawn from the evidence. Now, when he crossed over to the east side of Bundy where they had more light, the dog stayed with Steve. He stayed and they continued to walk. But as they walked, at each house that there was a pathway, the dog stopped and barked, looking up the pathway. This dog was acting very strangely. Obviously, it had seen a very traumatic event. Whether it actually witnessed the murders or simply came up on the bloody aftermath, it's clear the dog saw something. Now, when Steve got home, he took the dog into his courtyard, and he was able to see that there was blood on the underside of the belly, and there was blood on all four paws. But the dog was not injured. Now, Steve's friend, Sukru Bostepi, if you recall, he was the one who found the bodies. Sukru agreed to take the dog from Steve for the night. And when you recall that when he took him into his apartment, the dog was acting so agitated and so nervous that he had to take it out for a walk, and he decided to let it lead him, perhaps lead him to where it lived. And the dog did lead him, and the dog pulled. The dog pulled, and as they went south on Bundy, the dog pulled harder and harder. And as they walked south on Bundy towards Nicole's home, when it got to the pathway that led up to Nicole's house, the dog stopped. and it looked up the pathway. And Sucru told you that had the dog not done that, he would not have looked up the pathway, and he would not have seen what he saw. But as it was, he did. And because he followed that dog's gaze, he saw a sight, probably the most horrifying one ever seen in his life, or hopefully ever will see. Now, Sucru told you that when he saw Nicole Brown lying on the ground, it was midnight. So we know that the murders occurred after 10 and before midnight. That's the window that we know we have, just based on what people observed and what people saw. Now I'd like to turn to the defendant's activities for that night. And I'm going to show you how during the time period preceding the barking, during the barking, and for over half an hour after the barking, the defendant's whereabouts are unaccounted for. Let's start with Cato. Cato was a necessary witness for us to call, but he was by no means a witness who was happy to testify for the prosecution, as you could tell. This was the defendant's house guest. Someone who started out as Nicole's friend and boarder, who found a better deal, certainly a cheaper deal, at the defendant's estate. You'll recall that he met Nicole after her divorce back in 1992 in Aspen. And when he went to a party at her house on Gretna Green in during 1993 or the end of 1992, he asked if he could rent the guest house on that property, and she agreed. And they made an arrangement that he would pay monthly rent and reduce that monthly rent to some extent by performing babysitting activities for her 2 children. Now, he lived there with her in Gretna Green for almost a year, filling in as babysitter for the children, a friend to her, and the children as well. But when Nicole moved in January of 1994 to Bundy, there was no separate home for him to live in, no separate guest house, and the defendant asked him not to go and move in with her. And he persuaded Cato to go and live with him at Rockingham for free. That was a very good deal for Cato. As you may recall, I even asked him, how much money did that save you? You know, to stay in a place like the defendant offered him, with the availability of the pool and the jacuzzi, tennis court, living on that estate in kind of like a studio apartment, probably would have cost him $600 a month. Or what did he say? I think we wound up estimating that the total amount of money he saved staying there for free was about $6,000. He was very indebted to the defendant. And the aspiring but none too successful at that point actor Cato saw also a career-wise move that was very good for him, because in the defendant he could have a connection. Get the picture here. Logically speaking, this man is indebted to Mr. Simpson. And he was not a happy camper to be a prosecution witness. And he certainly didn't want to come in here and give testimony that might prove damaging to him. And you could tell from his demeanor, I'm sure, that he was not about to volunteer anything he didn't absolutely have to tell us unless he was cornered. I don't know whether you remember it now. It's really been a very long time. But during his testimony, I brought out the fact that at the grand jury proceedings back in June of '94, I asked him whether he'd ever witnessed any fights between the defendant and Nicole. And when he was asked in front of the grand jury whether he ever remembered seeing them fight, he answered that he remembered only one. And I asked him, do you remember anything about the nature of that fight? And he said, no, only that it was one. Only that it was one. And then when he came into court here, ladies and gentlemen, when I asked him why he didn't we asked him what he meant by that one fight that he had witnessed. That was the 1993 call to Gretna Green that you heard on tape when Nicole Brown called 911 and the defendant was standing outside screaming, yelling obscenities at her, and broke the door down, and she was afraid for her life. That was the fight he was talking about. When he answered to me in the grand jury, I remember one fight, and I only remember that it was one. Now, when he gave that vague, almost meaningless answer, no one at that time knew about the 911 tapes, and so he could get away with it until that became a matter of public record, and we all found out. And I couldn't confront him with that because I didn't know about it, and that's how he slid around. and would have continued had it not been brought to our attention by other means. But you see, so at that time, he was safe. But when he got called on it, and you realize how only that it was one, and he's talking about that event, that gives you a sense of how much he wants to help Mr. Simpson. Now, although on June the 20th, when he was directly asked under oath about the past relationship of violence between the defendant and Nicole, he said almost nothing, as I've indicated to you. And when he was interviewed by Mr. Shapiro, 6 days before that, he was a lot more forthcoming. When he was interviewed by Mr. Shapiro, as I pointed out during his testimony, he brought out the 1993 Gretna Green incident. He brought out the fight at the Jenner's Christmas party in 1993. But when I asked him 1 week later, when he was under oath in front of the grand jury, I remember only one fight, only that it was one. Very different demeanor between the time that he spoke to me in front of the grand jury and the time that he spoke to Mr. Shapiro 1 week earlier. And doesn't that alone tell you how reluctant a witness he was for the prosecution and how much he identified himself and wanted to identify himself with the defendant's side? Now, after he spoke to the police, though, this is the position he finds himself in, so you know, so you understand why he had to come here and give the testimony he did. At the time he spoke to the police in the early morning hours of June the 13th, he didn't know that what he was giving was damaging evidence against the defendant. He only knew he heard thumps on his wall. That's all he knew. And the events that transpired that night. He knew they went out to McDonald's. He knew that they had gone through all the things that I'll point out later for you, but they went to McDonald's, they had a burger, they came back, he went to his guest house, Mr. Simpson stayed outside. He later heard thumps on the wall during a phone call. At that point, he didn't know the significance of what he was saying. And he would surely never have told the police any of those things had he known what they meant. And so the problem was that once he told the police what had happened that night, he was stuck. He couldn't go back on his word. He had given them a detailed statement. It wasn't like he had given something vague that he could slide around with. He gave a very lengthy, detailed statement to the police because he was telling the truth. He didn't know any better than to tell the truth. And so when he was called back before the grand jury, at the preliminary hearing and at this trial, he had to recount that same truth. And he had to tell you. He had to tell you. Now back to the timing. Cato told us that he was on the phone with a friend when the defendant came out to the pool area near his door. And he was able to pinpoint that time with the phone call bill that he had, because the phone call was a long-distance call. Now, the call was placed at 9:03, and it lasted for 7 minutes. And when he saw the defendant come out to talk to him, he hung up the phone. So it was about 10 after 9, and I think we do. At 10 after 9, approximately, and just so we have 9:10 here, maybe it was 9:09, the defendant came out to talk to Cato. This is a very, very significant conversation that they have. I'm going to come back to this a couple of times. So here's the first time. The defendant told Cato that he had only $100 bills on him. And he asked Cato if he had any fives for the sky cap. You may recall that. Asked him if he had fives. Cato went to look, and he realized he only had $20 bills. So he gave the defendant a $20 bill, which the defendant took. Then the defendant told Cato he was going out to get something to eat. He didn't invite Cato. Cato invited himself. Now, I remember when I heard that, I thought, what's wrong with this picture? This doesn't fit. If you're going out to eat and you only have hundreds, you need change, you're going to break that 100 when you go out to eat. Why do you have to ask Cato for fives? You've only got hundreds. Wherever you go, you can break it if you're going out already anyhow. So what's the point here? Now keep that thought in mind, because I'm going to come back to that. That's very significant. All right, that was at about 9:10. They left immediately and they drove to McDonald's in the defendant's Bentley. Did it strike you as odd that he'd take a Bentley to a drive-thru to the McDonald's when he's got a Bronco? It's not like there's no other car. Now, you've seen the picture of the defendant taken at the recital for his daughter Sydney earlier that night. And in that photograph, he's wearing black dress slacks and like a white polo type shirt and a black, looks like a shirt to me because you can see the seams in the sleeve and a collar to it with the sleeves rolled up. But Cato told you that at the time he saw the defendant, at approximately 10 after 9, the defendant was wearing a dark blue or black cotton sweat outfit that had long sleeves. So after the recital, the defendant changed clothes. And that's important too. I'll come back to that. Cato had several occasions to notice the defendant's hands during the drive to McDonald's and during the time that they paid and during the time they got change, and he noticed that there were no cuts on the defendant's hands. Or he didn't notice any cuts on the defendant's hands, to be more accurate. And that's actually an important distinction. You'll notice too, though, when you look at the photograph of the defendant in the recital, you can see his left hand. And you can see that as of the time of the recital, when he's posing with Sydney, there's no cut on the back of the middle finger of the left hand. And that's important. Now, what's probably even more significant than Cato's lack of observation of any cuts on the defendant's hand when they're in at the drive-through lane is this. Cato wound up paying for the food with his own money, paid for both of them. He handed the defendant the money, the defendant paid, defendant got change back, and gave it to Cato. Gave it to Cato. Wasn't the whole point of talking to Cato to get change for the sky cap, get fives for the sky cap? Okay, now you have another inconsistency here. First of all, he asked Cato to give him change when he's going out already, he can get it himself. Secondly, he has the opportunity to get change right there at the drive-through window, either take Cato's or break the 20 that Cato gave him, and he doesn't take that opportunity. That's important too. I'll come back to it. They returned to Rockingham, and Cato proceeded, wanted to indicate, when they returned during the ride home, the defendant wolfed his food down while he was driving. Cato saved his. And all of these facts are going to be tied in at the end of this presentation. So I ask for your patience. Bear with me. I want to stick with the timing right now so I don't get distracted. When they got back to Rockingham, Cato got out and he walked towards the house, expecting the defendant to follow him. But when he got to the front door, he turned and he realized he's not here. And he saw the defendant still standing by the Bentley, watching him. And he had not moved. So as Cato told you, he took the hint, turned and went to his room. Now, why didn't the defendant just walk in the house? Or, if he intended to go somewhere, why didn't he just get back in the car and go? Either in the Bentley or in the Bronco. Why wait for Cato to be out of sight? I'll come back to it. I just want to think about it for a minute. Now, as soon as Cato got back to his room, he called a friend, and fortunately the friend lived far enough away that it was a long-distance call, so we have his phone bill that indicates what time it was. And he indicated that he made that call as soon as he got back to his room. So the call was made at 9:37. So he left the defendant's presence at 9:36. And you can see here, at 9:36, the defendant was last seen standing in the driveway. From 9:36 until 10:54, the defendant's whereabouts were unaccounted for. So we have the beginning of our window of opportunity at 9:36. Okay, now I'd like to remind you of some testimony you heard about the Bronco. back up for just a minute, talk about the car. Cato said the defendant almost always parked the Bronco on Ashford. And when I asked him when during the 6 months that he lived there he could remember ever seeing it parked on Rockingham, he said that he couldn't come up with any answer. I did ask him if he'd seen the Bronco either when they left the house to go to McDonald's or came back, and he indicated that he didn't notice either way. He wasn't looking for the Bronco. But there was a witness who was out on Rockingham that night. He was out walking his dog between 9:30 and 9:45. That witness was Charles Cale. He was a neighbor of the defendants. And when he was walking his dog, he was a neighbor of the defendants, he knew where the defendant lived. And I think he indicated that he had even been on Mr. Simpson's property at some point. So he was walking his dog that night between 9:30 and 9:45. And as he did so, he walked down Rockingham. And he looked, and he could see, I think he indicated it was 60 yards away, but he could see, that'd be 180 feet, that there was no Bronco parked on Rockingham when he was walking his dog, approximately between 9:30 and 9:45. Now there are two inferences we can draw from this. Either one is reasonable. Either the Bronco was on Ashford, which is why he didn't see it on Rockingham, or Mr. Simpson had already left in the Bronco by the time he walked his dog. Now, Mr. Cale also indicated that when he left his home on June the 13th at 7 a.m., when he drove down Rockingham, he did see the Bronco. And you notice it was parked at kind of a funny angle to the curb. Now, what that tells us then, we have two reasonable inferences, and I'm going to talk to you about this a little bit later. We have a jury instruction on direct and circumstantial evidence. And that jury instruction tells you that when you have two inferences, both of which are equally reasonable, one of which points to guilt, one of which points to innocence, you are to adopt the interpretation that points to innocence. That is, if both of them are equally reasonable. Now, in this case, at the point that Charles Cale is walking down Rockingham and is walking his dog and sees no Bronco on Rockingham, since he didn't look down Ashford, it is equally reasonable that the Bronco could have been on Ashford as it is that the defendant had already left in the Bronco. The inference that points to the defendant that's less inculpatory, that is less incriminating, is that the Bronco was on Ashford. Let's take that one. Okay? So let's infer from his testimony that when Mr. Cale was walking his dog, the Bronco was on Ashford. What does that tell you? It wound up on Rockingham. That's where it was found in the early morning hours of June the 13th. No one's disputing that. The Bronco was moved. And the inference to be drawn from that is that the defendant was out in the Bronco and he moved it. But you don't have to rely on just that inference. We have more. And what we have two things. As you may recall, Dr. Baden was the defense witness pathologist. He testified that the defendant told him that he had gotten cut when he went on the night of June the 12th, as he was preparing to get into the limo, he went to get the cell phone from the Bronco. That tells you the cell phone was in the Bronco. I'm going to talk about how he got that cut a little later. The cell phone was in the Bronco. That's where he had to go and get it from when he was getting ready to get into the limo. If the cell phone was in the Bronco, and he's using the cell phone that night, he was out in the Bronco. And we have the proof for you in the form of the defendant's phone bill. Here's the exhibit that we marked during the trial. You will have this one back there with you. It indicates that the defendant made 2 phone calls on the night of June the 12th from his cell phone that we now know was in his Bronco at 10:03. Now, in terms of timeline on that night, what this tells you is that the defendant was out in his car at 10:03. Now, at that time, he made phone calls to Paula Barbieri. You may recall we heard the testimony of the, I think it was Llewellyn Robertson of AirTouch, and she told you, she interpreted the record for you and what it meant. And she told you that the calls were not completed, but we didn't need her to tell you that. The calls to Paula Barbieri were not answered because Paula Barbieri was in Las Vegas. She was not at home, either in Florida or in Los Angeles. She was in Las Vegas at the Mirage. You recall we had a witness testify to that. She checked into the Mirage at 2 p.m. on June the 12th. So she was not available to take those calls. Now, I think we have further corroboration for the fact that the cell phone was in the Bronco in the fact that Alan Park, the limousine driver, testified that he saw, as they were loading up the limo, he saw the defendant go out towards Rockingham, out to where we know the Bronco was parked, once or maybe even twice. So there is further corroboration for the fact that he went and got the cell phone out of the Bronco just before they left. Now, those phone calls are very significant in terms of their timing, because you realize that at 10:03, when he's out in the Bronco and he's made those calls, that the murders occurred about 10 to 15 minutes after that. So we'll talk more about the state of mind that he was in at that time. We'll do it a little later. Now, Cato. Let's go back to Cato. He indicated that at about 10:15 or 10:20, and he's very approximate on these times. He's not looking at his clock. I think he readily admitted that to you. He made a phone call to his friend Rachel Ferrara, and that was a local call, so unfortunately we don't have a phone record to establish exactly when it occurred. This is an estimate on his part. Now, he testified, and I'm sure you recall it, that during that phone call, and he thought it was about half an hour after he made the call, he heard those thumping noises on his wall, very loud. So loud and so strong that the wall he was leaning on shook and a picture moved. And he said it was right in the area of the air conditioner that hangs over that narrow, dark south pathway. Those noises got him so upset. He suspected that it was an earthquake. He also told you he had suspicions that it might have been a prowler. And so he decided that he would go and see what might have caused them. And he told Rachel, he was scared and worried enough that he told Rachel that if she didn't hear from him in the next 10 to 15 minutes, to call the police. Now, he may have said it half-jokingly, but it's pretty clear he was worried. He was shook up. He was very shook up by those sounds that he heard, which is why he kept coming back to the issue, and he kept trying to talk to the defendant about it. And Alan Park, the limo driver. Now let's talk about Alan Park for a minute. You remember, he was the young man who had never been to Brentwood before. So he decided to make sure that he wouldn't be late. And although he was not supposed to be there until 10:45 for this pickup to LAX, he left at 9:45 to be on the safe side. And you may remember that this was a witness who was absolutely neutral. Absolutely neutral. He was not going to strain to avoid answers. He was not going to make any effort to embellish anything. This was a witness who was just going to tell it straight and tell it honest all the way through, no matter who was asking the questions, myself or the defense. And he stood up there and he took the grilling for a very long time. I went back and I counted. The cross-examination and re-cross-examination by Mr. Cochran took up 175 pages of transcript in these proceedings. Now, he told you that on that night, he was driving down Sunset. He made a right at Rockingham and drove up Rockingham at 10:22. Now, he looked at his clock and his watch many times that night. And the reason he did is very obvious. He's a driver. It's important that he be on time. It's important to him. It's important to his job. And this was an important job. I mean, he's going to drive for Mr. Simpson. You know, it's not just me, somebody like that, or somebody that ordinary average folk. It's important. He wants to do well. And he certainly doesn't want to be late, make Mr. Simpson miss his flight. So he's checking that clock. And at 10:22, he drives up Rockingham. And he's looking at the curbs to see the addresses because he's never been there before. And he wants to see 360 Rockingham. This is also logical. I mean, what do you do when you're looking for an address? You look at the curbs and you try to see where it is. And that's what he did. But when he did that, he saw no Bronco parked on Rockingham. And he was looking right there at the curb. Do we have the picture? This is People 62A, Your Honor. Kind of looks faded on the... Oh, you can see it, right? See that curb area? You can see there's a 360 there. Now, as he was driving up, he said, I could see the 360 on the curb. Now, if he could see the 360 on the curb, and you can see where the Bronco is right there, that big white car, he's not going to miss it. He's going to see it. If he's driving slowly enough to see the number on the curb and realize that he's hit the defendant's address, then he's obviously paying enough attention to see a big old white car there, and he didn't see it. So we know that at 10:22, the Bronco was not on Rockingham. But we know more, because we know at this point, when Alan Park turned the corner onto Ashford, he told you he did not see any Bronco on Ashford either. So as of 10:22, that Bronco's gone, and the defendant is gone. That's further corroboration for what we told you with the phone calls in the Bronco. He was out in that Bronco on that night. So he indicated that he turned right onto Ashford, he made a U-turn, and he parked across the street from the defendant's home from the Ashford gate side. He got out of his car. Remember, he went and sat on the curb behind the car and had a cigarette, waiting for it to be time to start buzzing for the defendant. And when he got back in his car, he looked at the clock, and he saw that it was 10:39. Now, at 10:39, he decided to check out the other gate, the Rockingham gate, and see if that would be easier to pull into than the Ashford gate. Because remember, he told you he had that stretch limo, kind of hard to maneuver. So, you know, what gate he went in and where he was, this was an important consideration for him. The logistics were not that easy with that car. When he drove down to the Rockingham gate, he told you that he pulled the driver's side window parallel with the driveway so that he could look into the driveway and see whether it would be easier for him to get the stretch limo up that side of the driveway, because of the way it curved. And you guys remember, you were there, you saw it's a curving driveway. When he did that, the area where the Bronco was found on the curb just north of the Rockingham gate was well within his field of vision, but he didn't see it. Again, further corroboration. The Bronco was not there. Now, he backed up Rockingham, and he backed all the way up past Ashford and then made a left back onto Ashford. And at that point, he actually pulled up into the Ashford gate so that the headlights would be almost up against the Ashford gate, I think he indicated. And he told you that he saw a 300ZX, a black one, parked to his left on Ashford Street, just to the left or east of the gate. And Cato told you, that's right, that was my car. That was there. And you even see it in some of the photographs that we've shown you during the course of this trial. Now, when he pulled up facing the Ashford gate, Mr. Park told you that it was 10:40, and he looked at his clock. At that point, he turned off his headlights and left the parking lights on, and he got out to push the buzzer at the Ashford gate. He wanted to let the defendant know that he was there. He pushed the buzzer, he told you, a good 2 or 3 times, and he heard the buzzing and the ringing noise as he did that, but he got no answer. He was concerned because the pickup was supposed to be, he told you, for 10:45. It's starting to get up there now, so he called his boss, and he wanted to ask him what he should do. 。  . 。 . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . And I have a board that shows Alan Park's cell phone record. And that was a very important cell phone record because that helps us to fix a lot of events that were testified to that otherwise would have been very approximate. With the help of his cell phone record, we have much more definite times, much more precise. He made the call to his boss at 10:43. You can see, we show you when the call begins and when the call ends. Dale St. John was his boss. And he called his pager. After he placed that call, he told you that he got out to ring the intercom a few more times. So now he rang the intercom at 10:40, no answer. 10:43, no answer. And he said he rang it a few times on each occasion, no answer. He noticed that there were no lights on downstairs and that there was one light on upstairs. He got back in the car and he called his mother. And he got his boss's home phone number and called him again at 10:49. And you see that call. We have a lot more calls in here. But at 10:49, he called his boss again. And he left a message because he got no answer. Now, when he left that message at 10:49 for his boss, after he hung up, he got out and tried the buzzer again. Now, this is the third time he's tried to get someone to answer that buzzer at the gate. The third time that he rang 2 or 3 times. And this third time again, he got no answer. Now, he also testified throughout all these events, getting in and out of the car and buzzing. You guys can sit. I'll come back to it in a minute. I want to wear you out. Thank you. He told you also, if you recall, that during this time that he was out by the Ashford Gate, he was paying attention to who was there. He was trying to reach the defendant, but he was very focused on whether he could get somebody to answer the buzzer, on whether he could get Dale St. John to call him back. I mean, these were the things that were occupying his mind, and he was carefully concerned about this because he had to get to the airport. But he was not listening for traffic. He was not listening to hear if a Bronco pulled up, and it wouldn't have been, he told you, it would not have been significant to him if he had heard a car pull up or a car door slam. So what? He's thinking, I got to get somebody to the airport. He's not thinking what cars are driving by, who's here, who's not here. He just wants to get going. He's late, and he's worried about that. So, although it would have been nice if he could have told us that he heard the Bronco pull up on Rockingham when it did, he just wasn't paying attention to that. And so he can't give us any information on that. We know the Bronco did pull up. We know it did because it got there. We know it wasn't there as of 10:39 when he drove down on Rockingham, and it was there later that night. All right, back to Park. Now, after he tried the buzzer at after calling his boss at 10:49, he got out. It was when he was actually buzzing at that point. Let me back up for a second. He called his boss at 10:49 at home. He got no answer. He went out to the gate and he rang the buzzer again 2 or 3 times and got no answer. While he was at the gate that third time, he heard his car phone ringing and he went back into the car. It was his boss calling him. That call came in. That last call came in at 10:52. And he indicated now, he told you about the fact that his boss called him, and he told his boss that no one had been home, and he'd been ringing for a while, and he was very concerned because he was running late. Now, at that time, I asked him, were you seated in your car when you were speaking to your boss? He said, yes. Where were you looking? I was looking through the gate right into the driveway. Well, what is the driveway lighting like? What is it like in there? Well, it's not really very well lit. The play area down in front, I'm going to pull out a diagram of Rockingham in a minute and show you exactly what I mean. It was dark, though. There were very little light. There was a light over the garage, but it gave very little illumination, and it did not light up the south pathway area at all. So he sat in his car talking to his boss, looking straight through the gate and at the driveway. Okay, this is just to get you oriented in case you forgot. It's been a while since we went out and did the walkthrough at Rockingham. So you see the area that says play yard there, and Park indicated that area was very dark. He indicated also, as he was seated in his car at the Ashford gate, that he could not see the Rockingham gate from where he was seated. He indicated to you, you see where that line is drawn at the garage? He saw nothing below that line. His field of view was limited to what was in front of that line. And that's because of the lighting that was at the driveway. Now, when he told his boss about no one being home and it was running late, his boss said, well, sometimes he does run late. Mr. Simpson does run late. Why don't you look at the lighting in the, I believe he said the pantry area, because he usually watches TV there. Well, Park checked the area, looked, and he couldn't see any lighting coming from that area, and he told that to his boss. During this conversation, Alan told you that he saw Cato come out on the side yard where the arrow is pointing, roughly in that area. I think it was a little bit farther back towards the tree, the other tree, that one. And he was holding a flashlight. You recall he told you that? And at the same time, he said almost simultaneously, he saw a person approximately 6 feet tall, 200 pounds, African American, wearing all dark clothing, walking at a good pace up the driveway. Okay, I'm going to ask Mr. Fairlow to hold off. I wasn't watching his arrow. I want to try and be precise, if I can, about where Mr. Park said he first saw this man. Go ahead and use the arrow. I'll tell you where. You can turn it around. All right. I believe it. Now, let me say this, because I know I'm going to forget if I don't say it when I think of it now. If you have any questions about anything that is said by either myself or by the defense during argument as to whether or not it is accurate, you can ask to have the record read back. Court reporters hate me for saying this, but in a trial this length, you're probably going to need to have your memory refreshed about something. And it's real important that you not, if your memory conflicts, if your notes conflict with what we're saying, you've got to have that resolved. If you need to have the record read back to have that resolved, then do it. And if you think that something I have said has been a misstatement, believe me, I'm not trying to. I'm trying to be very, very accurate here. But in case everybody makes mistakes, in case I make a mistake, have the record read back. I believe the testimony indicated that he saw this person approximately where the arrow is. And he saw him walk up the driveway and into the entrance. Now, he hung up within 30 seconds of seeing that, which means that, according to the cell phone bill, the call ended at 10:55 and 12 seconds. Approximately 30 seconds before that is when he saw the man walk into the house. And immediately, as soon as the man walked into the house, the lights started to go on. They went on downstairs. Now, Alan waited in his car, thinking that someone would let him in. But no one did. Now, if you recall, Cato said that he had gone out to that side yard to investigate the thumping noises. And when he saw the limo driver, he figured that the limo driver was already taken care of and that the defendant would buzz him in. So he didn't worry about it. He kept on about his business, and he went down to that south pathway, if you recall, to start looking to see what was going on back there. So Alan got out of his car and buzzed again. And this was now within a minute of seeing the man walk into the house, the lights go on. Within a minute of that, Alan buzzed again. This is the fourth time. This time, he got an answer immediately. And the answer was given to him was by the defendant. The defendant answered and told him he'd overslept and he'd just gotten out of the shower and he would be down in a minute. Now, Alan told you that the man who he saw enter the house appeared to be the same size as the defendant and about the same height and weight. He would not stretch even one iota to draw the obvious conclusion that the man he saw walking up the driveway was the defendant. Of course it was. There was no one else there that night. It was the defendant. Who else could walk in the door, immediately turn on the lights, and then answer the intercom? I mean, this is an easy, reasonable inference to draw. Easy. But what's significant here is that he lied. Why did the defendant lie? Why, when he was just out in the driveway, walking into the house, dressed in all dark clothing, why, when he answered the intercom for Allen Park, did he lie and say, "I've overslept, just getting out of the shower"? We know it's not true. We know it's not true. Why was it important for him to make Allen Park believe that he'd been at home? And I think we all know the answer to that question. It's because he hadn't been at home. Because he'd just come back from Bundy. Now let's go back to Cato for a moment. That's concerning those thumps and when they happened. Cato said that he hung up from his call with Rachel pretty quickly after he heard the thumping. He estimated for you 2 to 3 minutes. Now, with Alan's cell phone call, Bill, we can be very, very precise about when that was. He indicated that he went out to investigate the noises, hung up with Rachel, went out to investigate 2 to 3 minutes after he heard the thumping. Alan told you he saw Cato and the defendant I'm saying the defendant, he said the man that looked like the defendant, you understand, I'm talking about what we know based on all of the evidence, that it was him. 10:54 he saw Cato, approximately. Because it was at the same time he saw the defendant. And he hung up 30 seconds after seeing him walk in the house and after seeing Cato on the side yard. So at 10:54, Cato was out in the side yard. Hearing the thumping noises 2 to 3 minutes before that means that he heard the thumping on his wall at 10:51 to 10:52. So what we have, about 2 minutes after the thumping, the defendant was walking into his house from the driveway, and Cato out in the side yard. In other words, we have the thumping and Cato walking out and the defendant walking out around at the same time. And the thumping happened very shortly, within half an hour of the murders. And the defense would have you believe, ladies and gentlemen, that the defendant's appearance on the driveway just 2 minutes after the thumping on Cato's wall is a coincidence. And the defense would have you believe that the thumping and the appearance of that glove, the defendant's glove, were unrelated events. And the thumps themselves, just think about that. Regardless of where or how they happened, just the fact that they happened shortly after the murders at the defendant's house and just before the defendant walked up his driveway in dark clothing, like the dark blue or black sweat outfit that Cato described, you just put those facts together and you realize what has happened. The defendant came back from Bundy in a hurry. Ron Goldman upset his plans, and things took a little longer than anticipated. He ran back behind the house, that dark, narrow south pathway. You all saw it. You were there in daytime, but imagine how dark it is at night. That dark, narrow south pathway, thinking he could get rid of the glove, the knife, in that dirt area in the back. You recall back behind the guest houses, there's a dirt area. It was just all dirt, not very well tended. But he was in a hurry. He was moving quickly down a dark, narrow pathway, overhung with trees, strewn with leaves, and in his haste, he ran right into that air conditioner that was hanging over that south pathway. And running into that air conditioner caused him to fall against the wall, making the wall of Cato's room shake. You recall that air conditioner. It was hanging low. You had to stoop to get down under it. And if you're in a hurry and you're not looking where you're going, in that dark, narrow pathway, you can see how it can easily happen, how someone in a hurry can do that. And it was just as simple as that. Simple common sense tells you that the thumping, the glove, and the defendant's appearance on the driveway almost immediately thereafter are all part one set of events, all connected in time and space. You don't need science to tell you that. You just need reason and logic.
All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. All right, Ms. Clark, are you prepared to proceed?
Yes, Your Honor. Thank you.
All right, you may resume.
Good afternoon, ladies and gentlemen. All right, when we left off, I was talking about the occurrence of the thumping, the gloves dropping on the south pathway, and the defendant's appearance on the driveway within a couple of minutes of each other. Now, while Alan Park was speaking to the defendant on the intercom at that time, Cato, who wasn't worried about Alan being left outside, went over to the south pathway and looked down the gate. Can we get 66D back, please? Put up that diagram again so you can orient yourself, because it's hard just talking about this in the abstract. Okay. Can we back out just a little bit more? A little bit more? There we go. And the south pathway, if you recall, is at the bottommost edge below where that area marked garage is. You might recall. And he said that he went over to that area, looked down there, went through the first gate, went as far as the second gate, but that flashlight was very dim. And he was worried, and he was scared, and he didn't want to go any farther. So he looked down there, but it was dark, and he didn't want to go any farther. He said that he could not see the portion of the pathway that was right outside the wall of his room where he'd heard the thumping. It was too dark. And he came back out without going actually any farther on the pathway. When he came back out, he realized that Alan Park was still waiting outside the gate. Now, this is after Alan had spoken to the defendant on the intercom. And when he realized that the defendant had not yet buzzed Alan in, he went and he let him in. Now, let me ask you this. Why didn't the defendant let Alan Park drive in to the driveway? Why leave him sitting out there at the gate? Why make him wait outside? Because the defendant was frazzled, ladies and gentlemen. He was hurried, and he needed to buy some time. Time to wash himself up, wash off the blood, change the clothes, and to compose himself, to appear normal, to appear calm, business as usual. So he bought himself that time, and he did not let Alan in. And when the defendant came downstairs, he had changed clothes. No longer the dark clothing that Cato had described him in earlier that evening. He was wearing stonewashed denim jeans, denim shirt, and carrying a garment bag. You remember that Louis Vuitton garment bag that's here in evidence. Alan estimated that the defendant came downstairs dressed like that, carrying the garment bag, about 5 to 6 minutes after he spoke to him on the intercom. I think Alan Park's words were a good 5 minutes. Could have been longer. This was an estimate by him. But before the defendant actually came down, Cato went to let Alan Park in the gate, let him in, and he immediately told Alan about the thumping noises he had heard. He asked him, did you feel an earthquake? The same thing he asked Rachel Ferrara, if you recall. She told him she hadn't. Alan said the same thing. I didn't feel an earthquake. Now, Cato was clearly upset clearly distracted and upset by that thumping noise he had heard. In fact, as you recall, he went to check that south pathway twice. Once before he let Alan in, and then a second time after he let Alan in. Because he had the conversation with Alan Park, asked him about the earthquake, if he had felt it, told him about the thumping noises. I think said he told him he thought, or he was thinking anyway, that it might have been a prowler. And after he let Alan in, he felt safer, and he went back to check the south pathway again. Again with that dim flashlight. And didn't get any farther than he did the last time, and still wasn't able to see as far as the area of where his room was, and it was still very dark back there. And he gave up. But so Cato was concerned enough to check that south pathway twice, talk to his girlfriend Rachel about it, saying, call the police if you don't hear from me. Talk to Alan Park about it. And he talked to the defendant about it. The defendant came downstairs, and he started talking to him. Did you hear that? Did you feel an earthquake? I'm really worried. I heard this thumping on my wall. I'm really concerned about this. He's really worried about it. And what does the defendant do? The defendant never went out to the south pathway to check what might have gone on back there, to check for the sound of the source of the thumping. The defendant never called West Tech Security, nor did he ever tell Cato to call West Tech Security. The defendant never called the police, nor did he tell Cato to call the police. In fact, he left without even setting the alarm and had to call Cato from the airport to tell him to set the alarm, something he had never done before. Now, having heard about the thumping noises from Cato, hearing Cato's concern about it, how Cato was trying to figure out why that happened or what was the source of it, and being very worried about it, knowing that he was going out of town, his daughter Arnell staying on the property, and would be there alone with Cato, he did nothing to check on the source of the thumping. He did none of the things you'd expect someone to do under those circumstances. That is, someone who didn't already know what caused the thumping. But you see, he did. He knew. So, of course, he was unconcerned. He knew it was no prowler. Certainly we knew it's no earthquake. Because he knew the thumps were caused by him bumping into the wall. And so he didn't have to be worried that Arnell was going to be in danger, or even Cato in danger, or his home in danger. Because it was not a question for him. It was something he knew about. And he acted like someone who already knew what the source of those sounds were. Unconcerned. Now back to loading up the car. Alan and Cato described how they loaded up all the bags, all except one. You may recall that there was testimony about a small dark bag that was on the edge of the driveway by the Bentley. And Cato, as they were loading up the bags, offered to go and get that bag for him. I'll go get that for you. The defendant said, no, I'll get it. And the testimony was that all of the bags were loaded by either Cato or Alan Park, except for that one. And after the defendant walked towards it, after saying, no, I'll get it, after he walked towards it, no one ever saw that little black dark bag again. Nor have we ever found the knife the defendant used, nor have we ever found the clothes that he wore during the murder, nor have we ever found the shoes that he wore during the murder. And it's so typical. It's so common. They get rid of the murder weapon, they think that's it. Can't get me. And it's so typical. It's so common. They get rid of the murder weapon, they think that's it. Can't get me. Home free. But you see, as you've seen, it's not that easy. Evidence was left behind. So we don't need the murder weapon, because we have much, much more proof than that. Now, while they were loading the bags, Alan, as I told you before, saw the defendant go out to the Rockingham gate, where we saw that the Bronco was parked. Now, I referred to this earlier, that the defendant told Dr. Bodden that he'd cut his hand while getting the cell phone out of the Bronco. I'm going to show you why that does not explain all of his blood in that car. And I'm going to show you that he did not receive that cut on his finger from the cell phone. Now, the defendant stood in the foyer talking to Cato for a few moments. Can we get a photograph of that? And that's when he dripped blood. You see the little marker in that photograph. But after he came downstairs, the testimony went, he never went upstairs. Cato stood with him. Cato was talking to him. Cato went inside the foyer with him, went towards the kitchen at one point looking for a flashlight, you may recall, because Cato was asking the defendant for a better flashlight to go and look down that south pathway. Cato was standing by him, but the defendant was moving around the cars, getting things loaded up. But no one ever testified that he went back upstairs. And I think that it was Cato's testimony. I think Cato only testified to going into the house with the defendant once, and that was to get the flashlight. And they had also a conversation at that time about setting the alarm when Cato said, I don't want to set the alarm. I don't want the responsibility. I don't know the code. And the defendant said at that time, okay, I'll set it. And then he forgot and called him from the airport. Now, Alan Park indicated, I think, that he saw the defendant go in and out of the house a couple of times, but he never brought any more bags out. He only brought one bag out with him, and that was the garment bag as he came downstairs the first time. That was the only time he saw him bring a bag out. But Alan Park was busy loading the limo, and he was not watching the defendant carefully. Cato was hanging by the defendant. Cato was asking him, talking to him about the thumping, and he was trying to get his attention about something that he was very concerned about, because he was going to be left on that property alone with whatever caused that thumping noise. Cato didn't know. So he was talking to the defendant. He was asking for the flashlight, and he was talking to him about setting the alarm. And so Cato was the one who was more carefully tracking where the defendant was going, and Cato talked to him about what I told you, the flashlight and the alarm. Now, the defendant left, and when he left, as you know, he didn't set the alarm. While he was in the limousine, he asked the limousine driver to turn on the air conditioning. He complained repeatedly of being very hot. He rolled the windows down. Boy, it's hot. Boy, it's hot. You have the weather report, and it'll indicate to you it was a cool night. The defendant kept complaining about being hot. Man, I'm hot. Rolled down the windows, turned on the air conditioning. I asked Alan Park, were you hot that night? No. I asked Cato, were you hot that night? No. It was a cool night. Now, I said I'd show you that the defendant did not get that big cut on his middle finger from that cell phone when he went to get it from the Bronco. Let me show you something. You recall the testimony that blood was collected from the bathroom upstairs, that's just off the defendant's bedroom. And the blood is found basically in between the sink and the shower in the defendant's bathroom. The defendant was bleeding in his bathroom when he was cleaning and changing his clothes. Obviously. That was before he went down to the limo, ladies and gentlemen. Before he ever went to the Bronco. He already had that cut by the time he got downstairs. He got it long before he went out to that Bronco to get that cell phone. So since we know he was bleeding upstairs in his own bathroom, and before he went down to the limo, how come there weren't any blood stains on the staircase? Obviously he didn't fly. And just as obviously, he also bled downstairs. I show you that foyer picture. You've seen that quite a number of times with the blood spots on the floor. So he left blood downstairs as well. There are two possible reasons. We didn't see photographs of blood spots on the staircase. Number one, they were there and they were missed. Seems doubtful because it's a light carpet, light color carpet. Blood should show, but it's possible. Or two, the cut temporarily stopped bleeding. As you may remember, Dr. Huizinga testified that a cut will bleed, clot up, re-bleed, and I'm sure that wasn't news to you. I mean, that's life experience that's common to all of us. You'll cut yourself, you'll bleed for a while, and then maybe your hand will be still, and then you'll re-bleed if you exercise it or you rub it against something, you irritate it somehow. But in any case, by the time the defendant got downstairs with the garment bag and started loading up the limo, the cut was temporarily sealed. Now here's the interesting thing about the blood trail on his driveway and the blood in the foyer. When you take into account the blood in the bathroom, doesn't it make sense that he actually reopened the cut while he was moving around getting ready to go? You know you have the blood in the bathroom before he gets down to the limo, so he was already bleeding. You know that you don't have blood spots in between the bathroom and the foyer, so at some point the bleeding stopped before he left his bedroom. But you do know that you have more blood downstairs. You have blood leading out to the Bronco. Now, Alan Park told you that he saw the defendant go out toward the Rockingham gate as they were preparing to leave. And you know that the defendant told Dr. Bodden that he went out to the Bronco to get his cell phone from the car. Now, although we don't know for a fact based on photographs that he certainly did not receive that cut on some razor-sharp cell phone, it certainly does make sense that when he went out to get the phone, he opened the door to the Bronco and his knuckle grazed the well of the door handle, reopening the cut. You gonna have the Bronco door? You see where the spot is, and then Dennis Fung is holding up the number 1. You see that little speck there? Picture yourself at the door at the car, okay, and you're up to the driver's door. What hand do you use to open the door? Your left. Especially one like that, where you have to push the button in to open the door. Using his left hand. In which case, this middle knuckle is going to graze that door. In which case, a cut that has just temporarily sealed seconds or maybe minutes earlier is going to get irritated and rebleed. Now, this is just common sense, but when you open a car door, obviously, you need to use the handle. When you close a car door, you don't. How do you close a car door? Slam. Very simple. So by the time he opened the door, before he reached in and got the cell phone, that cut was bleeding again. You have him bleeding before he comes down to the limo up in his bathroom. You have him going down to the Bronco and opening the door. But either way you look at it, he's already bleeding before he gets the cell phone. And that's shown to you by photographs. Now consider this possibility. He opened the car door, grazing his knuckle on that door, reopening the cut, and after getting the cell phone out, walks back up the driveway, dripping blood, walks into the foyer, talks to Cato about getting a flashlight that's better or stronger than the one he's got, talks to him about setting the alarm, and while he's talking to him, he's standing in the foyer. Have that foyer. All right, he's standing in that foyer. Can we get the close-up? All right, now you see those 2 drops down to the left of the number 12? It's kind of faint on this picture. You're going to have the pictures back in the jury room, and I think they'll be better and clearer for you than this is. Those are big drops. Those are big blood drops, folks, not the kind you see from that little slice that Dr. Bodden showed you on the defendant's finger. Now, we've all been living in this world for a while, and you know that when you get big drops of blood, that's from a big cut. You're not going to cut yourself on get a little slice, like almost looking like a small slice on the inside of that finger, and drip blood like that. It just makes, this is common sense stuff. It's just very logical. Those drops came from a big cut, and we're talking about this cut on the middle finger. Now, did the defendant notice at that point that he was bleeding? Maybe. Maybe not. Maybe he did. Put something small on it, get ready to go, let's go. But in the rush of getting ready to leave, Cato, who's worried about a burglar back there, Alan Park, who's worried about getting to the airport on time, no one's paying attention to Mr. Simpson's hands. His finger is not the foremost thing that they're worried about here. Now, about the blood on the outside of the car door, I want to make one thing clear. I'm not saying that the blood could only have gotten on the well of that door handle at Rockingham.
Counsel. Forgive me for interrupting you. Let me see. Counsel to sidebar with the court reporter, please. All right. In fact, ladies and gentlemen, let me ask you to step back into the jury room for just a moment. Counsel, as I mentioned to you at sidebar, the reason that I interrupted Ms. Clark, and Ms. Clark, forgive me for the interruption, but while I was taking my notes here on your argument, I noticed that the television camera panned along the defense counsel table, and Mr. Cochran did a close-up of your client taking notes. And it's not appropriate for the television camera to be going along sidebar close enough that one can see what people are writing in their notes, and that's not appropriate. And I thought it would not be necessary to tell the television coverage that that's not appropriate. But apparently it's necessary to tell them that it's not appropriate. And it's a very flagrant violation and intrusion into the attorney-client privilege, and I'm inclined to terminate the coverage at this time. All right? So, Mr. Bancroft, I'm going to direct you to turn the camera to the seal, and the television coverage is terminated.
And obviously, a very startling announcement by Judge Lantito. Those of you who are watching could see what we could see from this vantage point. It did appear that although the defendant could be seen taking notes, I have never seen a time when any of the people who were sitting at the counsel table there, that their notes could be read in any way. I don't know why it is that Judge Ito concluded that simply because the defendant could be seen to be writing, that you could tell what he was writing.
Well, it's hard to believe at this point because none of the defense counsel objected and said anything. This was on the judge's own accord. And so at this point, from what I could see, you couldn't see what he was writing. And it's a little surprising. You would expect him to ask those kinds of questions, to review the tape for a minute, to see if in fact...
May I interrupt you here?
Sure.
We are reviewing the tape, and we're going to show it here to our viewers, but go ahead with your point, because you're making it's what appears to be quite a valid point, and we're going to check it out in a moment.
Right, and I think that at that point, if they were really concerned, you would have seen the defense attorneys object, and then the judge asked to run the tape to see, in fact, if you could see what he was writing, to see if it had been a particular infringement upon that attorney-client privilege.
You know, if it appears as I saw it, we do have the videotape. It is now queued up. We're going to have a look at it here, and then we will be able to see what perhaps Judge Lance Ito couldn't see, and that is we cannot see, of course, now whether anyone here is taking notes. It does pull back now. O.J. Simpson is seen to be taking notes. His hands there are shown. He's tearing off some piece of paper. Each of you can judge for yourself whether any person could have been able to read what was seen there. I think Judge Ito has a monitor where he can see what's on the screen there, and there was a movement in there toward O.J. Simpson's hands. I can't believe that Judge Ito himself could read what was there, because I clearly couldn't.
Well, Fred, I'm thinking there's one other point here, and that is there's been a lot of criticism of the fact that he allowed TV cameras in the first place. And it may be that at this point being sensitive to that kind of criticism over the time, that this was just the provoking reason for him to decide that he's going to show everyone that, at least in this instance, he's not going to allow anything close to any kind of infringement on the attorney-client situation. But from what you could see on those pictures, it's very clear that they were looking at what O.J. was doing with his hands, and there wasn't really anything you could see that was written that would have disclosed anything. And it looked like he tore off a piece of the paper, and that's it.
You know, Art, you started to say something. You said, at this point. It seems to me that this point is almost incredibly inopportune time to suspend television coverage after all of these months of having coverage. I mean, we've passed the volatile stage. We've passed the stage where perhaps emotions wore thin and anger arose. And here we are at the end when rationality and reason is supposed to assert itself, and in fact, that's obviously the approach that Marcia Clark is taking. And, you know, in many ways, this is the part the public really should see. They should see how, at least from her point of view, she makes it all hang together. And the public is going to have to judge the result of this trial. If they don't get to see all this, isn't it going to be more difficult for the public to know if what results from the jury deliberations are justified by the facts?
Well, that certainly would be the argument, and I would think that the judge ought to reconsider here, especially if he later reconsiders and they show all of the defense argument and not all of the prosecution argument. And I think it's very important for people to see how the prosecutors think about the evidence that they've introduced in a way of tying it together in their final argument. This is a critical part of the case for people out there to understand just exactly what their theory is and how they thought they did prove it. And it's the same with the defense. And so I would agree with you. At this juncture, it really is incumbent upon the judge, it would seem to me, to think it through and to think, is this a serious violation? Is there any violation? And should this be the point at which you suspend TV coverage?
We want to inform you that a Court TV executive, Cindy Glozier, who you may recall is the Court TV official who appeared before Judge Lance Ito right back in the first of the trial and spoke with him after Court TV had unintentionally shown a very brief glimpse of the side of a juror's face. She explained to the judge how that was inadvertent and how we would take steps that it would not happen again. Cindy Glozier, who does have a good rapport with Judge Ito, has taken the tape of that brief incident which we just showed you. In my judgment, it clearly shows that there was no effort there to see what O.J. Simpson was writing, and that clearly with these eyes you could not come near to reading what he was writing. She's taken that across the street, the criminal court building you see behind me. She will make every effort to show that to Judge Ito to clear this up as soon as possible, and we certainly hope that we can clear up what I think is a misunderstanding and resume our regular coverage. Dan Abrams is standing by. Dan, what do you have for us at this point?
Well, Fred, they are now taking a break in the courtroom. Now, I'm told the reason they're taking this break is to allow Kelly Sager, a media attorney, to make an appearance in the courtroom with a copy of the tape and to make an argument that the cameras should be permitted back inside that courtroom. Kelly Sager passed me by about 30 seconds ago on her way down with Cindy Glozier, as you pointed out before, a senior producer with Court TV who made a copy of that tape in order to give it to Judge Ito.
Our jury panel.
And Judge Lance Ito is now back on the bench.
My apologies to you for those interruptions, and my apologies to Ms. Clark for having interrupted her train of thought there. A couple of things happened that I needed to deal with immediately, and I apologize to you for the disruption in the thought process. We will go through at this point until 5 o'clock, and then we'll take our mid-afternoon recess. And however, I realize that since we're having extended hours, one or two of you may have a need for a comfort break. So if you do, just raise your hand, get the bailiff's attention, and we'll take a quick 5 or 10 minute break if you need to during the longer hours. Ms. Clark.
Thank you, Adam. Good afternoon. Okay. So now we've talked about conduct, we've talked about opportunity and timing. Let's talk about the physical evidence. I'm not going to do it in the detail you've already heard it, heaven forbid. But although you've already seen with the opportunity evidence, with the conduct evidence. We already have evidence to show you that the defendant did commit these murders without even really getting into the physical evidence. And once you see the vast array of physical evidence, you can see that there's virtually an ocean of evidence to prove that this defendant committed these murders. What all of it does, all of this evidence, is it links the defendant to the victims and the crime scene at Bundy. Now, the defense has gone to great lengths to try and to show that they could discredit this evidence, and the lengths that they have included have been some of the most bizarre and far-fetched notions I think I have ever heard. They've hinted that blood was planted. They've tried to create the impression that multiple other blood stains were contaminated and that somehow all the contamination only occurred where it would consistently prove the defendant was guilty. So now the little amplicons, the little DNA, they're co-conspirators too, because they know they've got to rush to only the places where you can attribute the blood to the murderer. When you think about that, just think about that one point logically, okay? Obviously, it's common sense. If contamination is going on, you're going to see it going on all over the place. As a matter of fact, if what they're saying is true with this aerosol effect, flying DNA all over the place, then Mr. Simpson's blood type ought to be showing up in other cases. Somewhere, somewhere out or down in another department in a rape case, Mr. Simpson's type should be showing up because it's everywhere. Or even just to confine it to this case. Talk about that. How come, if the argument is that his blood is flying all over the place, DNA is flying all over the place, why didn't we find his blood type showing up where it obviously shouldn't be? What I mean is this. They took samples from the pool of blood by Nicole's body. They took samples of blood that was near Ron Goldman's body. Obviously, the blood came from them because they were lying there. And then, of course, you have the blood drops leading away from the crime scene. That had to be left by the killer. There's no question about that. That was left by the killer because they're next to the bloody shoe prints. So you know. Why is it that the sample of blood they took from her pool of blood didn't come up with the defendant's blood type? If the defendant's blood type DNA is flying all over the place, it's flying all over the place. Then it ought to be all over the place. Why isn't it in the pool of blood sample that was taken from Nicole Brown? Why isn't it in the pool of the blood sample that was taken from near Ron Goldman's body? Logic, common sense. It ought to be there. The DNA, the amplicons, those little things, they don't know where to go. They're not guided. Contamination is a random thing. Happens willy-nilly. And what you have here is they're trying to get you to believe that only the killer's blood was contaminated, and it was consistently contaminated with only the defendant's blood type. Does this make any sense to you? What you ought to have, if you have contamination, if you've got a problem here, is that some of the blood drops come back to the defendant and some don't. They come back to the real killer. That's what you ought to get, because it can't be this consistent. If you had one blood drop in this case, ladies and gentlemen, you might be concerned with all of these possibilities they've raised, but you have so many. You have so many. You've got 5 blood drops leading away from the bodies of the victims out to the driveway, and you've got the blood on the rear gate. And that's the other part of their scenario that makes no sense. No sense. You have all these police officers that were there on June the 13th. Officer Risky saying his partner, young rookie named Officer Terrazas, shined his light on the rear gate to show him the blood on the rear gate. You have Officer Risky seeing the blood on the rear gate. You have Officer Rossi seeing the blood on the rear gate. You have Detective Phillips seeing the blood on the rear gate. All of it early on. Dennis Fung, whom you can see, is not the model of efficiency, forgot to collect it. And from this we get a theory that they seem to imply that the blood was planted. Why do they say that? Now, first of all, I want to hear Mr. Cochran actually stand up in front of you and tell you he believes the blood was planted. I want to hear that, because that is incredible. That is absolutely incredible. When you think about that, think, what evidence have you been given to show you how that blood was planted, to show you when that blood was planted, to show you who planted that blood? Now, the reason that they have to come up with this story about contamination and planting, and I want to hear if they really, really do that, say that to you, is because they can't get around the result. You recall Dr. Gerdes testified for the defense, and he said that the DNA testing that allowed for RFLP, the most powerful of the techniques of DNA, was successful on the rear gate because that blood had higher molecular weight DNA. From the fact that you have higher molecular weight DNA on blood collected later, July 3rd, they want you to infer that somehow it was planted. But they're inconsistent because if you remember, now if you plant the blood, aren't you going to plant it close to the time you collect it? What are you going to do? Plant it and hope somebody finds it later? You plant it when you expect someone to find it, right? When they have the EDTA going on, you have all these cross-examination questions about EDTA breaking down due to sunlight exposure. There's no proof that that happens, by the way, as you could tell. And they did no tests to prove that that happens, by the way. Would be nice. If they want to prove that, do a little testing. You've got the expert right there. Why didn't he do any tests, by the way? But he didn't do any. Okay? So they're asking him about EDTA breaking down in the sunlight, trying to infer that it was there for 3 weeks, that the blood was there. If it's there for 3 weeks, it wasn't planted, folks. It was there on the night of the murder. This is what I mean by inconsistent, illogical. This makes no sense. If you're going to say that the blood was planted, then you're going to say that it was planted at or near the time of collection, in which case the EDTA would not break down, in which case the EDTA should be intact, in which case you should see the kind of high, smooth arc that the graphs showed you from the reference tubes, instead of the jagged noise that you actually saw. And they brought in Dr. Readers to try and tell you that that jagged noise looks just like that high arc, which is ridiculous, which is insulting to your intelligence. But the reason that they have to say this, defying logic, defying common sense, is because, ladies and gentlemen, his blood on the rear gate, with that match that makes him 1 in 57 billion people that could have left that blood. I mean, there's 5 billion people on the planet? That means you'd have to go through 57 billion people to find the DNA profile that matches Mr. Simpson's. There's only 5 billion people on the planet. Ladies and gentlemen, that's an identification. Okay? That proves it's his blood. Nobody else is on the planet. No one. Now they know that. Now the blood on the socks. Nicole's blood on the socks. Again, RFLP match, very powerful. Showed from Cellmark, that was a 5-probe match, I believe, found to be 1 in 6.8 billion people. Again, more than there are people on the planet, identification. An 11-probe match by DOJ showed that it was 1 in 7.7 billion people. Again, her blood, and only hers on this planet, could be on that sock. Now, how do you get around that? It wasn't wrong, and they couldn't find an expert who would say it was contaminated because there's too much DNA. That is the blood. That type is the type. It is her blood. How do you get around that? And if you know that that's true, if you know it's her blood on his socks that they find on the morning of June the 13th, that alone, with the rear gate stain, convicts him. You can't believe otherwise. You have so much proof now. How do they get around that? They have to find a theory to get around that. And what do? This is what they come up with. So if it's low in volume DNA, it's contaminated. If it's high volume DNA, it's planted. And it's also very convenient and ridiculous. Now, their experts had access to all of the evidence in this case. Their experts could have come in and shown you how the evidence got contaminated. Not possibly. Remember I talked to you about mere possibility? No, did get contaminated. And they could have come in here and told you and pointed out the evidence that showed why only the blood drops left by the murderer got contaminated, and shown you why they consistently and only got contaminated in a way that showed the defendant's DNA type. Not that they possibly could have. Yes, possibly we're all sitting on Mars right now, and I'm from Venus and I'm talking, anything's possible. Let's talk about what did happen. Let's talk about what we've got. They could have shown you proof that the Bundy blood drops were contaminated, not the mere possibility. No, I'm talking about evidence that gives you a reason to conclude that that happened, and that they never could do. And they could have done it if it were true. But they didn't. And not one expert they brought in on the DNA did even one test on the blood evidence. The evidence that we have that proves to you that the defendant committed these murders. Not one. With all those experts you saw. And the reason for that, ladies and gentlemen, is that it isn't true. The blood on the Bundy trail comes back to the defendant because it's his blood. The blood on the rear gate comes back to the defendant because it's blood he left there on the night of the murders. So they took you through all this tortured and twisted road. One moment saying that the police are all a bunch of bumbling idiots. The next moment they're clever conspirators. And now ask yourself, did they ever prove who planted? When? How? And it's a fact that the defense doesn't have to prove anything. That's a fact. But once they do decide to put on a case, once they decide to try and prove something, their witnesses are subject to the same scrutiny as the people's witnesses are. Your jury instruction, as I've told you, makes no distinction. It's up to them to do the best job that they can to make their point. And I think a good example of how they failed to do that miserably in this case is the EDTA, that preservative that you find in the purple top tube. They've got to make you believe that blood was planted. It's the cornerstone of their defense. It really is, because as I've pointed out, if you know that's his blood left on the rear gate, if you know that's her blood on his socks, what are you left to conclude? Now, what do? To show you, to prove to you the cornerstone of their defense, what do? They take our tests, and they have some other expert who neither did the test himself nor could come in and try and interpret those graphs for you. Not only that, but he does it inconsistently. He writes a report, if you recall, he wrote a report in which he said he found one parent ion and one daughter ion, not the full daughter spectrum that would permit identification of EDTA, but the same finding of one parent ion, one daughter ion, that Mr. Martz said he found in his own blood, in his own unpreserved blood, which does prove that the blood on the rear gate, the blood on the socks, are just like Agent Martz's unpreserved blood, natural blood, not from a preservative tube. So what did they do with that? Here's what happened. Dr. Reeders wrote that report, and he said the blood on the sock, the blood on the gate, one parent ion, one daughter ion. Wrote that report, I believe, on July 17th. A few days after he wrote the report, he found out that Agent Martz had just done the test on his own blood and come up with the same result he got on the sock and the gate. Very, very low noise readings, and only 2 of the 3 ions he should have found, which leads you to understand that it was unpreserved blood. Well, now he's got to do something about that. He has to answer that contradiction, because now what we've got is he can't address this. We have proven conclusively it was not EDTA blood. He's got to do something to make his testimony weave its way around. So he gets up and on the stand for the very first time on this witness stand. He makes a new conclusion, and now he says, I find a peak that shows the second daughter ion on the sock. Dr. Reeders, what happened between the time of your report and your testimony? Did you do some tests? No. Did you do some experiments? No. Were there some new graphs? Yes. Agent Martz's blood. Not new graphs on the sock. Agent Martz's blood. He had to change his testimony to encompass evidence that refuted his conclusion completely. But what they gave you is somebody who did not one test. With access to all the evidence, he tested nothing. They have the experts to do the test. They did nothing. They have the experts to do experiments to prove things they want to prove about it. Nothing. That's the cornerstone of their defense, ladies and gentlemen. They did nothing. Now, what does that tell you? What that tells you is they know this is not EDTA blood. Saying it's so doesn't make it so. Having a lawyer stand up in front of you and say something, no matter how often it's said, doesn't mean it's true. I include myself in this. You know, I only argue what the facts have shown and any reasonable inferences that you can draw from them. That is all. I cannot stand before you and tell you something that is false, that is untrue. You need to go with what is true, with the evidence, with what we have, and the reasonable, common sense deductions that you make from that evidence. I don't ask you to take my word for anything. That's why we present on evidence. That's why we call witnesses. If it isn't in the record, or it doesn't make sense to you as a logical inference from what you've heard, reject it. I don't care who says it, reject it. But do the same for the defense. Hold me to that standard, hold them to that standard. When you hear them try to tell you that all of this evidence was either contaminated or planted, ask yourself, does this really make sense? What evidence was I given to prove that? Is there any evidence that really shows that? Or is it smoke and mirrors? Is it all the smoke to cloud everything, cloud all the issues, distract you? Take a little piece here, take a little piece there. Kind of reminds me of that story about all these guys that are blindfolded, and each one goes to a different end of an elephant. One grabs the tail, and he says, feels like a rope. And the other guy grabs the trunk, and he says, feels like a fire hose. And another guy grabbed the leg and said, feels like a tree. Okay? Not one of them got it right, did they? You take off the blindfold, it's an elephant. You put all the pieces together, you put the whole picture together, and you can see the truth. But what they have done systematically is fragmented the case. Now, this is not new. You know, I mean, they did a very good job of it. They're fine lawyers. And they challenge the people's case as they should. And that's good. You put the state to their proof. That's what we have to do. We have to deliver. That's our job. And we have. But be aware of what's happening here. They're fragmenting. They take little pieces out of context and focus on only that little piece. And take a little piece of a picture, focus on only this little piece of the picture, and forget about all the rest. That puts it all in context. Give Henry Lee second-generation photographs that he can't see anything on, instead of the good stuff, the original photographs that would show him what's going on Bundy Walk there. Now, back to DNA. I'm sorry, I digress. Even when it's analyzed using the PCR method, it's not quite so easily contaminated as the defense would have you believe. As you've learned, it's used every day to save lives. And as you've also heard, it's used in very non-sterile conditions. It's used to identify war dead. Now, what does that mean? War dead, soldiers who die in jungles and in deserts. Those are not sterile environments, ladies and gentlemen. Those are very dirty environments. But they use PCR testing to identify those soldiers. And why do they do that? So they can notify next of kin. That's a very serious responsibility. You better be right. You better be right. Now, if it's good enough to go and notify next of kin that their son, their daughter, their husband, their father has been murdered or killed, on a battlefield, then it better be good and reliable stuff. So if it's good enough for that, on body parts being recovered from jungles and deserts, it's pretty hardy, pretty durable. Now, Dr. Lee, the defense expert they gave none of the DNA evidence to examine, who is a forensic expert, approves of DNA testing in criminal cases. Notice they didn't ask him to look at the evidence here. Notice they didn't ask him to tell what he thought of the results in this case. A forensic expert, a criminal expert. They didn't ask him. Who'd they bring in? Dr. Gerdes. Dr. Gerdes, who has admittedly no experience in forensic cases, came in to tell us about validation studies and dot blots. But what did he do in this case? What forensic criminal experience does he have? Zip. None. Why do you even use a guy like that in a criminal case when you've got Dr. Lee? And don't forget Dr. Blake. Dr. Blake, who is renowned as a scientist, who is one of the foremost experts and leading ones in the forensic use of PCR technology, whom they had watching the testing at DOJ, examined the evidence in this case, took cuttings of the evidence in this case at Cellmark, never sat in that blue chair for the defense. Why not? Where was he? If you have evidence to prove that there is something, that there is contamination in these samples, you have an expert who is there watching the testing, who is an expert in the field of PCR, does it in criminal cases all the time, he's renowned, you never call him. What sense does that make? What does that tell you about what you've been given here in the nature of the defense? Smoke and mirrors, ladies and gentlemen. And by the way, when DNA degrades, as you've been told, it doesn't turn into someone else's type. You get no result. And you may remember, no result. I mean, degrades, nothing. You may remember that Dr. Cotton testified. She was asked, well, how would a swatch in which DNA is all degraded get contaminated with another person's type? How could that happen? She said, well, really, they've got to be touching. The swatches would have to come in contact. A swatch of somebody else's type would have to come into physical contact with a swatch where the DNA had completely degraded. She could not envision flying DNA, as they have tried to sell you in the defense, because DNA just doesn't jump or fly. And don't forget, in case you had, we even did prove that their contamination theory was untrue. If you remember, we had a lot of testimony of what we call substrate controls. Now, all the substrate controls are, it's really, I think you'll remember, it's very simple. You go and you collect a blood stain from here, and then, in order to make sure that the blood type you're going to pick up there isn't the result of something underneath that was already there before the blood came down, you take a little swatch right next to it to show that the ground underneath didn't have any DNA. And we did that. That was done at Bundy, next to every blood stain, systematically done. Now, how do they help you? When you go to test the swatches, the blood stain swatches and the controls are tested the same way. And if you have contamination, the controls should come up showing DNA. And the controls on the Bundy walk did not. And there you go. Oh, I wanted to go over an instruction with you. This is a long instruction that has particular relevance to this case. It's called, this is the instruction about circumstantial and direct evidence. There's a lot of words in this instruction, I must say. Let me first say something to you about direct and circumstantial evidence. This instruction explains them both. I don't know how well. I'm not a big fan of these, the way they're written. I think they could be a lot clearer, frankly. But they talk about direct and circumstantial evidence. This one is just circumstantial evidence. You have another instruction that distinguishes between the two. You're told in these instructions that direct and circumstantial evidence are of equal weight. Neither one is better than the other. Now, an example of direct evidence would be an eyewitness, someone who would say, I saw him, I saw that. We have an eyewitness in Alan Park, okay? His testimony seeing the man we know to be the defendant walking into the house at Rockingham. Alan Park testified to his observations. That's direct evidence, okay? Circumstantial evidence is evidence that leads you to infer, okay? For example, in this case, the blood. The blood at Bundy, dripped by the killer next to the bloody shoe prints. It's not direct. Somebody didn't see the murder being committed, didn't see the murderer leaving the scene of the crime, but you have the blood of the murderer left behind. It's kind of like well, and you have the blood on the rear gate that actually identifies Mr. Simpson. That's kind of like a fingerprint. Okay? That's circumstantial evidence, as opposed to seeing it. Now, in terms of quality, there's no difference. The law has no favorites. But when you think about it logically, circumstantial evidence has a lot of benefits that direct evidence doesn't. What is that? It gives you a lot of quality assurance. It gives you independent corroborating bases on which to believe that the defendant is guilty. Instead of relying on one person's observation, one person who might be mistaken, who might be tired, who might not have observed very well. You know what happens because you saw it happen in this case. What happens with an eyewitness? They start out saying, for example, a robbery, okay? I was standing on the street corner and I saw the defendant go over to the woman and grab her purse. Okay, purse snatch. Okay, cross-examination. How far away were you from that woman? Where were you standing? Were they standing in shadow? Do you wear glasses? How much of the defendant's face did you see? Half? 3/4? Only a quarter? What kind of hair did he have? What kind of shirt did he wear? What kind of pants did he wear? What color eyes did he have? Did he have a goatee? Did he have a mustache? Did he have a beard? And so on and so forth. And the witness starts to get torn down. And if that's all you've got is that person's observation, it can make you a little unsteady about whether or not you really have enough proof to give you that certainty that you need. Now, contrast that with the following. You have the defendant committing a purse snatch. And what you have is someone who hears the woman scream, sees the back of a man running, and then a few minutes later, the defendant is caught 3 blocks away holding her purse. Assume for a moment that she cannot really identify her attacker. You got him with her purse just a few minutes later. A lot of things can be said about how it got to him, but that's circumstantial evidence. But even that circumstantial evidence is not nearly as good. It doesn't come close to what we have in this case. In this case, you have circumstantial evidence of the blood, you have hair and fiber, and you have some of the conduct evidence and the opportunity evidence. You have a wealth of evidence in this case, all pointing to one person, the defendant. Now, this instruction, usually when I see lawyers argue this, they take out one paragraph and they only talk about that one. I want to talk about the whole instruction here. Okay, begins in the very first paragraph with the fact, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only 1, consistent with the theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. You'll see the word reasonable, rational throughout these jury instructions, because that's what it's all about. Reason, common sense, logical, rational. All right, now I'm going to jump around between this, and I'm going to come back and forth to this instruction because there's a lot here. But in the third paragraph, this is what I told you about a little bit earlier. If you have 2 reasonable interpretations, remember I gave you the example of the Bronco that could have been on Ashford or could have been gone completely at the time that Charles Cale was walking his dog. You had 2 reasonable interpretations from that evidence when he said he couldn't see the Bronco on Rockingham. At the point in time that he testified, based on his testimony, you had 2 reasonable conclusions to draw. Either that it was not there at all, or that it was on Ashford and he didn't see it. When you have 2 reasonable interpretations, one of which points to guilt, and the other to innocence, you adopt the interpretation that points to the innocence and reject that interpretation which points to his guilt. That is when they are equally susceptible of 2 reasonable interpretations. If, on the other hand, one interpretation of the evidence appears to you to be reasonable and the other to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. reasonable, rational. The defense will argue to you many things, inferences that could be drawn, just like the possibilities I talked to you about. Ask yourself, are they reasonable? Because if they are not, if those inferences are not reasonable, then you are to reject them and accept the reasonable. And that's why I keep referring to common sense, rational, logical. All right, I'd like to start with hair and fiber. If you remember, Mr. Diedrich testified about the microscopic comparisons of hair and fiber in this case. And when he did so, well, first let me point something out. His testimony was uncontradicted by any other expert. His testimony is not disputed. His conclusions are not disputed. And you know that the hair and fiber evidence was examined by at least 2 other experts for the defense. Now, when Mr. Diedrich testified, he told you what his conclusions were based solely on what he could see through the microscope. That's all he can tell you about. He did not take into account the results of the DNA testing. He didn't take into account the testimony of Cato or of Alan Park. None of that. He looks through a microscope. So all he can tell you is that the defendant's hair shares the same microscopic characteristics as, for example, the hair in the knit cap found in Bundy, or the hair found on Ron Goldman's shirt. He can only say it's consistent, shares the same microscopic characteristics. But when you take into account all of the evidence, including the DNA, including the testimony of Cato and Park, including the defendant's opportunity to commit the murders, including his post-homicidal conduct, you know it's his hair. You know it's that fiber. So now we are going to put it all together. So when I talk to you now about that's the defendant's hair in the cap, I'm talking about not just Doug Diedrich's testimony. I'm talking about his testimony along with everything else, all the reasonable inferences that you can draw, all the logical conclusions that you come to, knowing all that we know in this case. Now, I'm not going to talk about every conclusion that Mr. Diedrich testified to. Some of them were only testified to give you more information, more background, more knowledge about what you expect to find in this testimony. So let's start. What I'd like to do is start with the bodies at Bundy and move away from them as the defendant moved away from them after the murders, and analyze all of the evidence that was left behind from that perspective. And just so you know, I will show you a couple of photographs from the crime scene, but I'm not going to put up any coroner's pictures. I've seen enough of that for a while. So when I describe the wounds from the coroner and that sort of thing, I'm just going to describe them. You're not going to see pictures from me. You can see them back in the jury room if you like. All right, let's start with the knit cap. Can we get the Bundy board? The knit cap. You can barely see it under the plant here. This is the position in which it was found. Now you can see how the defendant could miss it in the dark. It's underneath that plant. I'm pointing to it right here, that blue, patch of blue here. On that knit cap, you recall that it's the defendant's hairs. Now let me refer specifically to Mr. Diedrich's testimony in this regard, because what he told us is this. He said there were the hairs that he said were consistent with the defendant's. He found 9 inside the cap. And it's clear, extrapolating from his testimony, it's clear that they were 9, I think, naturally shed hairs is what he said. Not fragments, but naturally shed hairs. That he wore the cap from that. Now, what's interesting also is that he talked about fragments that were found inside the cap, hairs of black origin that were not consistent with Mr. Simpson's. And so I asked him, what about those hairs? Well, he said they were treated, chemically treated. How long were they in the cap? Can't tell. They could have been there for years. Because you can, life experience, if you ever had anything knit like that, kind of a loose weave, and you'll have it in evidence, you can check it out. It's going to get hairs in it, and those hairs could stay there for a very long time if it's not washed, if it's not laundered. So that's why I asked the defendant's hairdresser, Could it have, what about the defendant's former wife, Marguerite? Did she treat her hair? What about Arnell? Did she treat her hair? These are other possible people that could have worn the cap and whose hair could, the fragments, old fragments, could be from. But the 9 naturally shed hairs inside the cap that were consistent with the defendants were different in quality than those because they were not fragments and therefore unlikely to be old. All right, and taking into account everything that we know, those were his hairs in the cap. He wore the cap. He also found on that cap fiber, and he said it was consistent with the carpet from the defendant's Bronco. And he talked to you about the unusual nature of the trilobal cross-section of that fiber, and he showed you photographs of it that were taken from the scanning electron microscope. You'll have that back in the jury room if you want to see it. It's very interesting stuff. But what we know, from all we know, that was a fiber from the defendant's Bronco on that cap. Now that's very important because that actually, with that cap, we have tied the defendant and his car to the crime scene at Bundy. And now you see, to summarize, on the knit cap we have the defendant's hair and the Bronco fiber from the carpet in his Bronco. And another piece of the puzzle. Now let's go to Ron's shirt. Now on Mr. Goldman's shirt, we have the defendant's hair and we have the blue-black cotton fiber. Now, of course, the defendant's hair is of obvious significance. Mr. Diedrich was asked whether or not that hair appeared to be the hair that he said was consistent with the defendant's, whether it appeared soiled. He said no. That was very important, and that was very important for this reason. If we had simply found hairs of the defendant in the soil of that area in Bundy where Ron Goldman was lying, we probably would not think that was a big deal. Why? He visited the place. He was there, pick up the children, leave the children, and that there might be stray hairs lying around in the soil, falling from whatever reason. This would not be very significant. I wouldn't be standing here talking to you about it right now. But you have an unsoiled hair on the victim's shirt. That's important. And that makes the distinction. Because if it had been something that he picked up from the soil, then you should have seen dirt in it. The fact that it was unsoiled means it was the result of contact between the defendant and Ronald Goldman that night during the murders. We certainly have no reason at all to believe there was any contact between the defendant and Ronald Goldman before the murders committed. We have something else on Ron's shirt. We have the blue-black cotton fibers. All right, so what's the big deal about that? Well, you recall that Mr. Diedrich found blue-black cotton fibers in 2 other places. And the blue-black cotton fibers that he found that shared the same microscopic characteristics as those he found on Ron Goldman's shirt were found on the Rockingham glove and on the defendant's socks. So what could that be? Well, clearly, those are fibers from what the defendant was wearing that night. You recall what Cato described. He was wearing the dark blue to black cotton sweatsuit with long sleeves. Now, a sweatsuit has banded ankles and is going to be in contact with your socks. Obviously, too, a sweatsuit, if you have an elastic ankle, exertion, you're going to pull the pants up. It's going to rub. There's going to be some friction there. And it's natural, of course, it's also common sense, that you will find fiber from one piece of clothing transferred to another, which is why, if you recall, when he was testifying, I asked him, did you find any of Ron Goldman's shirt fibers on his jeans? Yeah, I did. Not a surprising thing. Very common. Same thing happened with the defendant. And when he had contact with Ronald Goldman, when he attacked Ronald Goldman, he left fibers from what he was wearing on Ron Goldman's shirt. And when he went to take, and in wearing that sweatsuit over those socks, he left fibers on those socks. And in having maybe the Rockingham glove in his pocket when he was running down the south pathway, picking up fibers from it, from his clothing, when the glove fell out, it still had the fiber from his clothing. And that's why you have those fibers sharing the same microscopic characteristics with all the tests he performed on them, there were quite a few, in those three places: going to the crime scene, the south pathway, and the defendant's bedroom. So with this piece of evidence, we've tied the defendant to the murders, and this link carries us from Bundy clear into the defendant's bedroom in Rockingham. And here's a summary of what we've just discussed: the defendant's hair on Ron Goldman's shirt and blue-black cotton fibers. Yeah. And another piece of the puzzle. All right, now let's move away from Ron and start up the walkway. I'm going to direct your attention to the board. The bloody shoe prints. Now, the bloody shoe prints actually start down here. I'll just hold it up for a minute. On this very first photograph on the bottom, you can see the shoe print right next to the blue knit cap. It starts between, okay. And those bloody shoe prints go all the way down the walkway till you get to about halfway when they fade out. This is another important piece of evidence that proves the defendant's guilt. The shoe prints are all size 12. The shoe prints were all, and by the way, size 12, less than 10% of the male population wears that size. And the men who wear that size tend to fall within the height range of 5'11" to 6'4". The defendant is 6'2". And these are not just any size 12s. They're expensive shoes. Casual shoes that cost $160. Not dress shoes. Shoes that would be worn by a rich man. The kind of man who would wear cashmere-lined gloves. And what's even more important is that those shoes were only sold in 40 stores in this country. Out of how many thousands, maybe even millions of stores in this country, these shoes are only sold in 40 of them. And one of those 40 stores was Bloomingdale's, the store the defendant shopped in regularly, where he would buy shoes, both dress and casual, as you heard the testimony. They stopped selling those shoes back in 1992, but during the time that they sold them, the defendant was shopping at Bloomingdale's. Now, as we move down the walkway, we see that there's only one set of bloody shoe prints. Mr. Boziak, I think, made that very clear, especially on his last visit. Only one set of the imprints were bloody shoe prints. And all of them were consistently Bruno Magli, size 12. And there's the summary. Defendant's shoe size is 12, less than 10% of the population. Expensive, rare men's shoes sold at very few stores. And another piece of the puzzle. Now we look to the left of the bloody shoe prints, and we see the blood drops on the walkway. These are the blood drops left by the murderer. I've already talked to you about that, and it's clear because they go all the way alongside to the left of the bloody shoe prints down that walkway. 5 blood drops, all of which match the defendant. Now, of the 4 inside the gate, 4 on the walkway that is inside the gate, all 4 were done with PCR. 1 was also done with conventional serology. You recall there was testimony about that from Greg Matheson, but all of them match the defendant. As we get to the rear gate, we see that there's more blood. And this blood also matches the defendant. Now, on the rear gate, I think I've already talked to you about that. The blood that matches the defendant was typed to 1 in 57 billion. In other words, that's identity. That is his blood. And then we go out to the driveway, and you recall blood drop number 52. And that drop was also done with RFLP. And in that blood drop out on the driveway, you have the typing, I think, determined with RFLP was that it was 1 in 170 million. The reason for the lower number is because they had fewer probes. It was a weaker sample. The reason for that, I'll talk about that for a minute. You have a different environment. And I think it's important to note, on the walkway, we don't have a good picture of it here. There are other pictures that you have in evidence that'll show this. The walkway is very dirty, and it's concrete. It's porous. It absorbs. On the other hand, on the gate, you have a smooth surface. It's up off the ground, and it's not as much in contact with dirt and with the elements, and it's not going to be absorbed in the gate because you have the paint on the gate that prevents it from doing that. Which is why you have higher molecular weight DNA. The more that DNA is subjected to bacteria, to dirt that degrades it, the more it's going to degrade, the less DNA you're going to have. The dirtier the environment, the less the DNA. The cleaner, less hostile environment, the more DNA. Very simple. So you have more DNA on the gate than you do on a dirty walkway. The gate is not the cleanest thing in the world, I guarantee, but you do have, it's up off the ground. You do have a non-absorbent surface. So that's part of the reason for the higher weight DNA. The other part of the reason is that the rear gate, by inference from all of the testimony, that stain was collected and taken down right away instead of sitting in plastic bags in a hot truck. All right. So you have all of the blood on the walkway matching the defendant. You have RFLP results on the rear gate that identifies the defendant. You have a drop on the driveway, 1 in 170 million. That's a virtual identification of the defendant under all of these circumstances as well. And another piece of the puzzle. Now let's talk about the Bronco. All right, first of all, just consider the fact that there's blood in the Bronco at all. I mean, ladies and gentlemen, do you have blood on the interior driver's door of your car, on the dashboard, on the console? I mean, think about that. And all at the same time? As for the amount of blood in the car, how much would you expect to see? When you think about it, the defendant inflicted the wounds that bled out on these victims, the ones that really bled out, from behind them, with the throat cut that was demonstrated to you by Dr. Lakshmanan. So if he's standing behind them, they're bleeding out this way, how much blood is he going to get on them? Not very much. And he certainly wouldn't be getting any on his back, which is where he's going to be in contact with the seat. It's his back and the back of his legs. No. Then he bled it all on his hands from touching. So the blood that you see in the Bronco is actually, logically speaking, where you'd expect to see it, from a cut hand or from a bloody glove that's dropped down next to the console. It's the amount you'd expect to see, it's where you'd expect to see it, given the circumstances of this case. Now let's talk about the cut finger. Look at where we found blood on the door. You found blood inside the well of the driver's door handle, and you found some closer to the driver's window. This blood in here, in the well of the driver's door handle inside the car, how do you get that blood there? Think about where you'd have to put your hand. Think about where you'd have to be sitting when you put your hand there. When you get out of the car, if you're seated in the car, in the driver's seat, and you need to open the door to get out, that's what you do. You put your hand in the door handle to open it in a seated position. So that blood got on there after when he drove back from Bundy with a bloody finger to get out of his car. That's the only position you could be in, to get the blood in the well of that door handle like that. Because to get it there, you're opening the door. And to be opening the door from inside the car, you'd be seated in the car. So now we know yet another fact that shows that he was bleeding in that car long before he went out to get his cell phone from the Bronco to leave for the airport. Now, the defense is not claiming that the defendant's blood in the Bronco was either planted or contaminated. They concede that one right up front. And that's because they can come up with an explanation for that one. Remember the razor-sharp cell phone. But remember, it's only the evidence that they can't otherwise explain that they resort to the desperation theories of contamination and planting. But it's not only the defendant's blood in this car. There's also the blood of Ron and Nicole in that Bronco. And there are other people who saw that there was blood in that car at Rockingham in the early morning hours of June the 13th. Recall another witness called by the defense, Officer Don Thompson, who was guarding the car and kind of taking care of business at Rockingham. He saw the blood in the Bronco as well. Now, you may remember that the blood on the console was initially collected. By the console, I mean the area here marked by the number 31. This number tag, it's in between the seats. Testimony was that Dennis Fung collected blood from that console on June the 14th at the print shed. That was before it went to Vertel's, that tow yard where it seems that everybody and his brother went to look at that car. Before it went there, Dennis Fung collected that blood. Now, the results of the blood collected by Dennis Fung in the morning of June the 14th indicated with PCR testing the presence of blood from the defendant and from Ronald Goldman. And it indicated that the response it was mostly the defendant's blood in that mixture. Now, you heard all the testimony about the insecure conditions at Vertel's and how the car was kept unlocked because they didn't have a key for it. And you may remember that the Bronco had to be towed from Rockingham because early in the morning when the police had contacted the defendant, if you may recall, Cato testified that the detectives asked him for a key to the Bronco because it was locked, they couldn't get inside it, and he couldn't find a key. And you may also recall that there was testimony indicating that the car had to be towed because it couldn't be unlocked. They didn't unlock it until the 14th when they had to do that with a Slim Jim. Basically had to break into it.